Uniform Securities Act, last revised or amended in 2002, drafted by the National Conference of Commissioners on Uniform State Laws and by it approved and recommended for enactment in all the states at its annual conference meeting in its 111th year in Tucson, Arizona, July 26 to August 2, 2002, with prefatory note and comments approved by the American Bar Association, Seattle, Washington, February 10, 2003. Copyright 2002 by National Conference of Commissioners ONUNIFORMST. ATELAWS, January 21, 2003. Drafting Committee to Revise Uniform Securities Act, Richard B. Smith, 450 Lexington Avenue, New York, 10017. Chair Justin L. Vigdor, 2400 Chase Square, Rochester, New York, 14604. Vice Chair John Fox Arnold, 714 Locust St. St. Louis, Missouri, 63101. Henry M. Kittleson, P.O. Box 3209292, Lake Wire Drive, Lakeland, Florida, 33802, 2092. Andrew Rickner, Room 585, P.O. Box 30014, Lansing, Michigan, 48909, 7514. Michael P. Sullivan, P.O. Box 39286, 7505, Metro Boulevard, Minneapolis, Minnesota, 55439. Howard J. Swibel, Suite 1200, 120, South Riverside Plaza, Chicago, Illinois, 60606. Robert J. Tennyson, 3400, City Center 33, South 6th St. Minneapolis, Minnesota, 55402, 3796. Lee Yeakel, P.O. Box 164196, Austin, Texas, 78716, 4196. Joel Seligman, Washington University School of Law, Campus Box 1120, 1 Brookings Drive, St. Louis, Missouri, 63130. Reporter ex officio K. King Burnett, P.O. Box 910, Salisbury, Maryland, 21803-0910. President Carl Lissman, 84, Pine St. P.O. Box 728, Burlington, Vermont, 05402. Division Chair, American Bar Association Advisor Alan P. Botten, 666, 5th Avenue, 26th floor, New York, 10103. ABBA Advisor W. Reese Bader, 1020, Marsh Road, Menlo Park, California, 94025. ABBA Litigation Section Advisor Charles Braisted, 167, Orchard Run 45, Rockefeller Plaza, Cornwall, Vermont, 05753. ABBA Business Law Section Advisor Executive Director William Henning, University of Missouri-Columbia, School of Law, 313 Hulston Hall, Columbia, Missouri, 65211. Executive Director Fred H. Miller, University of Oklahoma, College of Law, 300 Timberdale Road, Norman, Oklahoma, 73019. Executive Director Emeritus William J. Pears, 1505 Roxbury Road, Ann Arbor, Michigan, 48104. Executive Director Emeritus. Copies of this act may be obtained from National Conference of Commissioners on Uniform State Laws, 211 East Ontario Street, Suite 1300, Chicago, Illinois, 606113212/915-0195. www.nccusl.org. Uniform Securities Act Table of Contents. Article 1, General Provisions, Section 101. Short Title 10. Section 102. Definitions. 10. Section 103. References to Federal Statute ES. 35. Section 104. References to Federal Agencies. 37. Section 105. Electronic RICO RDS and Signatures. 37. Article 2, Exemptions from Registration of Securities, Sect. Ion 201. XEMPTSECURITIES. 38. Section 202. Exempt Transactions. 46. Section 203. Additional exemptions and waivers. 61. Section 204. Denial, suspension, revocation, condition, or limitation of exempt ions. 61. Article 3, Registration of Securities and Notice Filing of Federal Covered Securities, Sect. Ion 301. SECURITIES registrat ion REQUIREAMENT. 63 Section 302. Notice filing. 64 Section 303. Securities registration by coordination. 66 Section 304. Securities registration by qualification. 69 Section 305. Securities registration filings. 75 Section 306. Denial, suspension, and revocation of securities registration. 80 Sect Ion 307. Waiver and modification. 85 Article 4 Broker-dealers, Agent S, Investment Advisors, Investment Advisor Representatives, and Federal Covered Investment Advisors Section 401. Broker-dealer registration requirement and exemptions. 86 Section 402. Agent registration requirement and exemptions. 90 Section 403. Investment Advisor registrat ion requirement and exemptions. 93 Section 404. Investment Advisor representative registration requirement and exemptions. 95 Section 405. Federal Covered Investment Advisor Notice Filing Requirement. 98 Section 406. Registration by broker-dealer, agent, investment advisor, and investment advisor representative. 100 Section 407. Succession and change in registration of broker-dealer or investment advisor. 102 Section 408. Termination of employment or association of agent and investment advisor representative and transfer of employment or association. 103 Sect Ion 409. WITHD RA AL of REGISTRATION of BROKRDEALER, Agentee, Investment Advisor, and Investment Advisor Representative. 106 Section 410. Filing fees. 106 Section 411. Post-registrat ion requirements. 109 Sect Ion 412. Denial, revocat ion, SUSPENSION, WITHD RA AL, restriction, condition or limitation of registration. 113 Article 5 Fraud and Liabilities Section 501. General fraud. 123 Section 502. Prohibited conduct in providing investment advice. 124 Section 503. Evidentiary burden. 126 Section 504. Filing of sales and advertising literature. 126 Section 505. Misleading filings. 127 Section 506. Misrepresentations concerning registration or exemption. 128 Section 507. Qualified immunity. 129 Section 508. Criminal penalties. 130 Section 509. Civil liability. 132 Sect Ion 510. Recis Ion OFFERS. 139 Article 6 Administration and Judicial Review Section 601. Administration. 143 Section 602. Investigations and subpoenas. 144 Section 603. Civil enforcement. 148 Section 604. Administrative enforcement. 150 Section 605. Rules, forms, orders, interpretative opinions, and hearings. 153 Section 606. Administrative files and opinions. 155 Section 607. Public records, confidentiality. 156 Section 608. Uniformity and cooperation with OTHER agencies. 158 SECT ION 609. JUDICIALRFIU. 161 Section 610. Jurisdiction. 161 Section 611. Service of process. 165 Sect ION 612. Severability CLAUSE. 167 Article 7 TRANSITION Section 701. Effective date. 168 Sect ION 702. Repeal S. 168 Section 703. Application of Act to existing proceeding and existing rights and duties. 168 Uniform Securities Act, 2002. Prefatory note: there are two versions of the Uniform Securities Act currently in force. The Uniform Securities Act of 1956 Act, has been adopted at one time or another, in whole or in part, by 37 jurisdictions. The revised Uniform Securities Act of 1985, RUSA, has been adopted in only a few states. Both acts have been preempted in part by the National Securities Markets Improvement Act of 1996 and the Securities Litigation Uniform Standards Act of 1998. The need to modernize the Uniform Securities Act is a consequence of a combination of the new federal preemptive legislation, significant recent changes in the technology of securities trading and regulation, and the increasingly interstate and international aspects of securities transactions. The approach of this act is to use the substance and vocabulary of the more widely adopted 1956 Act, when appropriate. The Act also takes into account RUSA, federal preemptive legislation, and the other developments that are described in this preface and the official comments. The Act has been reorganized to follow in large part the National Conference of Commissioners on Uniform State Laws, NCUSLO, Procedural and Drafting Manual 15-41, 1997. This is a new Uniform Securities Act. Amendment of the earlier 1956 Act or RUSA would not have been wise given the different versions of the 1956 Act enacted by the states and the determination to seek enactment in all state jurisdictions of the new Uniform Securities Act after it was adopted by the National Conference. Nonetheless, several sections of this Act are identical or substantively identical to sections of the 1956 Act or RUSA. It is not intended that adoption of a new Uniform Securities Act will reject earlier case decisions interpreting identical or substantively identical sections of the 1956 Act or RUSA unless specifically so stated in the official comments. The Act is solely a new Uniform Securities Act. It does not codify or append related regulations or guidelines. The Act also authorizes state administrators in Section 203 to adopt further exemptions without statutory amendment. The drafting committee did not address state tender offer or control share provisions in its preparation of this Act. 1. The Act includes subheadings within sections as an aid to readers. Unlike section captions, subheadings are not a part of the official text. Each jurisdiction in which this Act is introduced may consider whether to adopt the subheadings as a part of the statute and whether to adopt a provision clarifying the effect, if any, to be given to the headings. The drafting committee reviewed several drafts in meetings between 1998 and 2002. The drafts were made available on NCUSLO's public website before the meetings. The meetings were publicly noticed and open to all who wished to attend. The committee had the assistance of advisors, consultants, and observers from several interested groups, including, among others, the American Bankers Association, the American Bar Association, the American Council of Life Insurers, the Certified Financial Planner Board of Standards, the Financial Planning Association, the Investment Company Institute, the Investment Counsel Association of America, the National Association of Securities Dealers, Inc., the New York Stock Exchange, the North American Securities Administrators Association, the Securities and Exchange Commission, and the Securities Industry Association. In addition, the reporter and the chair met on several occasions with committees or representatives of these and other groups. In drafting the new act, the reporter and the drafting committee recognized two fundamental challenges. First, there was a general recognition among all involved of the desirability of drafting an act that would receive broad support. The success of RUSA had been limited because of fundamental differences among relevant constituencies on several issues. After the National Securities Markets Improvement Act of 1996 preempted specified aspects of state securities law with respect to federal covered securities, the opportunity to draft an act in a less contentious atmosphere was available. Given the number of industry, investor, and regulatory interests affected by the Act and the complexity of the Act itself, building consensus was the Act's most significant drafting challenge. Second, there was the technical challenge of drafting a new Act that could achieve the basic goal of uniformity among states and with applicable federal law against the backdrop of 46 years of experience with the 1956 Act. Over time, both uniform and non-uniform Act states have, to varying degrees, evolved local solutions to a number of securities law issues. In an increasingly global securities market, the need for uniformity has become more important. Drafting language to achieve the greatest practicable uniformity, given differences in state practice, was a key aspiration of this Act. In a few instances, such as dollar amounts for fees, the Act defers to local practice. On a few other issues, bracketed language or the official comments articulate an alternative some states may choose to adopt rather than the language of the Act itself. The Act is in 7 articles, 1 general provisions 2. Exemptions from registration of securities 3. Registration of securities and notice filing of federal covered securities 2-4. Broker-dealers, agents, investment advisor representatives, and federal covered investment advisors 5. Fraud and liabilities 6. Administration and judicial review 7. Transition. There has 3 overarching themes of the Act. First, Section 608 articulates in greater detail than the 1956 Act's Section 415 the objectives of uniformity, cooperation among relevant state and federal governments and self-regulatory organizations, investor protection and, to the extent practicable, capital formation. Section 608 is the reciprocal of the instruction on these subjects given by Congress in 1996 to the Securities and Exchange Commission in Section 19, c, of the Securities Act of 1933. The theme of uniformity and the aspiration of coordination of federal and state securities law is particularly stressed in the Act and official comments. Section 602, f, consistent with the Federal Securities Litigation Uniform Standard Act of 1998, is a new provision encouraging reciprocal state enforcement assistance. A second overarching theme of the Act is achieving consistency with the National Securities Markets Improvement Act of 1996, NSMIA. New definitions were added to define in Section 102.6, Federal Covered Investment Advisor, and in Section 102.7, Federal Covered Security. NSMIA also had implications for several securities registration exemptions, see Sections 201.3, 201.4, 201.6, 202.4, 202.6, 202.13, 202.14, 202.15, and 202.16, Securities Registration, Sections 301.1, and 302, and the broker-dealer, agent, investment advisor, and investment advisor representative provisions, see especially Sections 402, b, 1, and 5, 403, b, 1, a, and 2, 405 and 411. A third theme of the Act involves facilitating electronic records, signatures, and filing. New definitions were added to address filing, Section 102.8, record, Section 102.25, and sign, Section 102.30. Section 105 expressly permits the filing of electronic signatures and records. Collectively, these provisions are intended to permit electronic filing in central information depositories such as the Web CRD, Central Registration Depository, the Investment Advisor Registration Depository, IARD, the Securities and Exchange Commission's Electronic Data Gathering, Analysis and Retrieval System, EDGAR, or successor institutions. Electronic communication also has led to an amplification of the jurisdiction Section 610. The new Act makes several other significant changes compared to the 1956 Act or RUSA. 1. The definition of security in Section 102(28) has been modernized to take into account amendments to the counterpart federal provisions, add new language to expressly include uncertificated securities, exclude contributory or non-contributory ERISA plans, and amplify the definition of investment contracts so that it can expressly reach interests in limited partnerships, limited liability companies, or viatical settlement agreements, among other contracts, when they satisfy the definition of investment contract. 3. The new Act does not expressly exclude from the definition of security variable insurance products, but does exempt variable insurance products from securities registration in Section 201. 4. The states are divided on the question of whether variable insurance products should be excluded, and not subject to fraud enforcement, or exempted, and subject to fraud enforcement. For those states that wish to continue to provide or adopt an exclusion for variable insurance products from the definition of security, the brackets should be removed from the phrase or variable. For those states that wish variable insurance products to be included in the definition of security, the bracketed phrase should be removed. 2. 19 new definitions were added to define bank, Section 102. 3. Depository institution, Section 102. 5. Federal Covered Investment Advisor, Section 102. 6. Federal Covered Security, Section 102. 7. Filing, Section 102. 8. Institutional Investor, Section 102. 11. Insurance Company, Section 102. 12. Insured, Section 102. 13. International Banking Institution, Section 102. 14. Investment Advisor Representative, Section 102. 16. Offer to Purchase, Section 102. 19. Place of Business, Section 102. 21. Predecessor Act, Section 102. 22. Price Amendment, Section 102. 23. Principal Place of Business, Section 102. 24. Record, Section 102. 25. Securities and Exchange Commission, Section 102. 27. Self-Regulatory Organization, Section 102. 29. And Sign, Section 102. 30. The growth in definitions is suggestive of the increased complexity and detail of several revised provisions in the new Act. 3. Specific exemptions from securities registration are broadened. Most significant is Section 202.13, which builds on a new definition of institutional investors that parallels Rule 501(a) of the Securities Act of 1933, but with $10 million rather than $5 million thresholds in Sections 102.11, F, through K, and O, and addresses specified employee plans, trusts, Internal Revenue Code Section 501, C, 3, organizations, small business investment companies licensed by the Small Business Administration, private business development companies under Section 202(a) 22 of the Investment Advisors Act, and other institutional purchasers. The definition of institutional investor also reaches qualified institutional buyers under Rule 144(a) I of the Securities Act of 1933, major U.S. institutional investors as defined in Rule 15(a)(6), b. 4, I of the Securities Exchange Act of 1934, and federal covered investment advisors acting for their own accounts. The new institutional investor transaction exemption in Section 202.13 will also reach other persons specified by rule or order of the administrator. The limited offering transaction exemption in Section 202(14) was broadened to reach 25 persons, in addition to those exempted by the institutional investor exemption, on condition that the transaction is part of a single issue, and other specified conditions are satisfied. If the SEC adopts a new definition of qualified purchaser, as it has proposed under Rule 146(c) of the Securities Act of 1933, there may ultimately be four preemptive or exemptive types of provision applicable to the new Act. 1. The SEC Qualified Purchaser Provision. 2. Section 18(b), 4, d, which provides preemptive treatment for Rule 506 offerings under the Securities Act of 1933. 3. Specified investors in Section 202(13), and 4. Limited offerings in Section 202(14). The options exemption in Section 201(6) was broadened. The manual exemption in Section 4202(2) has been modernized for an electronic age. A broadened exemption has been provided for specified foreign securities in Section 202(3). A new exemption has been added for non-issuer transactions in securities subject to Securities Exchange Act reporting in Section 202(4). A new exemption has been added for non-issuer transactions rated at the time of a transaction by a nationally recognized statistical rating organization in one of the four highest rating categories in Section 202(5)(a), and new exemptions were added for specified exchange transactions in Section 202(9), control transactions in Section 202(18), specified out-of-state offers or sales in Section 202(20), specified sales transactions in Section 202(22), and specified foreign issuers whose securities are traded on designated securities markets in Section 202(23). The administrator may expressly authorize one of three regulatory plans for the offering of notes, bonds, debentures, or other evidences of indebtedness for nonprofit organizations under Section 201(7). New conditions have been added to the unit secured transaction exemption in Section 202(11), to address two substantial areas of state regulatory concern. The emphasis in the securities registration exemptive area is on flexibility. Securities administrators are given broad powers both to exempt other securities, transactions, or offers in Section 203 and to deny, suspend, condition or limit specified exemptions in Section 204. 4. Relatively modest changes were made to Article 3, which concerns registration of securities. A new notice filing provision was added in Section 302 for federal covered securities. A generic waiver and modification provision was added in Section 307. New procedural provisions for stop orders were added in Section 306, d, through f. Merit regulation was among the most divisive issues that confronted the RUSA drafting committee. After the National Securities Markets Improvement Act of 1996 preempted states from applying merit regulation provisions to federal covered securities, this became a less controversial issue. The approach in this act retains two widely adopted merit regulation provisions in Section 306(a), 7(a), and (b)(a). The offering will work or tend to work a fraud upon purchasers or would so operate, or b. the offering has been or would be made with unreasonable amounts of underwriters and sellers' discounts, commissions, or other compensation, or promoters' profits or participations or unreasonable amounts or kinds of options. In addition, bracketed Section 306(a), 7(c), includes the less widely adopted formulation, the offering is being made on terms that are unfair, unjust, or inequitable. A new Section 306(b) provides, to the extent practicable, the administrator, by rule adopted or order issued under this Act, shall publish standards that provide notice of conduct that violates subsection a. 7. NASAA guidelines provide this type of published standard. This hortatory section is intended to address one type of criticism of merit regulation. 5. Article 4, which concerns broker-dealers, agents, investment advisor representatives, and Federal Covered Investment Advisors was substantially revised to take into account NSMIA and significant changes in administrative practice such as those occasioned by the electronic web CRD and the IARD. New developments had an impact on the definitions of agent, Section 102, 2, broker-dealer, Section 102, 4, investment advisor, Section 102, 15, and investment advisor representative, Section 102, 16. NSMIA led also to the new Federal Covered Investment Advisor Notice filing procedure in Section 405. A bank, savings institution, or trust company was excluded from the 1956 Act Section 401, c. Definition of broker-dealer. After the Gramm-Leach-Bliley Act was adopted in 1999, the generic exclusion of banks from the definition of broker and dealer in Sections 3a, 4, and 5 of the Securities Exchange Act of 1934 was rescinded in favor of functional regulation. At the federal level, this means that banks, unless limiting their securities activities to a specific list of excluded activities, are required to register as broker-dealers. This act generally follows the federal approach with exceptions for private securities offerings addressed by Section 3a, 4b, 7 of the Securities Exchange Act of 1934 and to minimize transactions in Section 3a, 4b, 11, which in the new act are limited to unsolicited transactions. The administrator is given a residual power in Section 102, 4e, to adopt further exclusions for banks, by rule or order. Securities issued by banks, other depository institutions, and international banking institutions are exempt from securities registration in Section 201, 3. Banks, savings institutions, and other depository institutions, when not excluded from the definition of broker-dealer, will be required to register by Section 401 and generally, like all other broker-dealers, be subject to the regulatory and liability provisions of the Act in Article 4 and 5. 6. Article 5 on fraud and liabilities and the definition of fraud in Section 102, 9, are substantively little changed. This includes the general fraud provision in Section 501, the filing of sales and advertising literature in Section 504, misleading filings in Section 505, and misrepresentations concerning registration or exemption in Section 506. Technical changes were made to the evidentiary burden Section 503 and the criminal penalties Section 508. Section 502a, fraud in providing investment advice, is unchanged. New rulemaking authority was added in Sections 502b and c to succeed earlier statutory provisions in Section 102 of the 1956 Act. This will give the administrator broad flexibility and recognizes that most state provisions regulating investment advisors in recent years have been adopted through rules. Section 507 is a new qualified immunity provision to protect a broker-dealer or investment advisor from defamation claims based on information filed with the SEC, a state administrator, or self-regulatory organization unless the person knew, or should have known at the time that the statement was made, that it was false in a material respect or the person acted in reckless disregard of the statement's truth or falsity. This section, which is consistent with most litigated cases to date and is a response to concerns that defamation lawsuits have deterred broker-dealers and investment advisors from full and complete disclosure of problems with departing employees. The drafting committee was also sensitive to the concern that such immunity could allow broker-dealers and investment advisors to unfairly characterize employees to protect their book of clients. Because of this concern, the drafting committee rejected 6 proposals for an absolute immunity. Section 510 is a new rescission offer provision that should be read with the definition of offer to purchase in Section 102, 19, and the exemption for rescission offers in Section 202, 19. Section 510 is consistent with administrative practice in many states today, although some states also have a filing requirement. More thought was devoted to the civil liability Section 509 than any other provision. As ultimately drafted, much in this section is little changed from the 1956 Act. New subsections were added to recognize the Preemptive Securities Litigation Act of 1998, Section 509A, and civil liability for investment advice, Sections 509E and F. Significant changes were made in the Statute of Limitations Section 509J. Current state law provides a wide range of statutes of limitations. The 1956 Act contained a 2 years after the contract of sale statute of limitations. The new Act has 2 statute of limitations provisions. Section 509J, 1, limits violations of registration provisions to 1 year after the violation occurred. Section 509J, 2, follows the pattern of federal securities law statutes of limitations, as amended in July 2002 by the Sarbanes-Oxley Act, and limits fraud violations to the earlier of 2 years after the discovery of the facts constituting the violation or 5 years after such violation. The derivative liability provision in Section 509G is not intended to change the predicates for liability for one who materially aids violative conduct. 7. Several changes are made in Article 6, which concerns administration and judicial review. Most are technical in nature. A new authorization for the administrator to develop and implement investor education initiatives has been added in Section 601D and E. Considerable attention was devoted to enforcement of the Act. The 1956 Act Section 408 was a slender provision providing for injunctions. Section 603 and 604, in contrast, provide a broad array of civil and administrative techniques including asset freezes, rescission orders, and civil penalties. Under Section 604 the administrator may issue a cease and desist order. 2 other enforcement provisions in the Act are, 1. Stop orders in Sections 306, D, through, F, and 2. Broker-dealer, agent, investment advisor, and investment advisor representative denials, revocations, suspensions, withdrawal, restrictions, conditions, or limitations of registration in Section 412. Each of the enforcement provisions in the Act includes both summary process and due process requirements either through judicial process or guarantees of appropriate notice, opportunity for hearing, and findings of facts and conclusions of law in a written record. Section 607 is a new provision that clarifies the scope of non-public records and the administrator's discretion to disclose in light of the extensive development of freedom of information and open records laws since the 1956 Act was adopted. 7. The jurisdiction and service of process provisions, Sections 610 and 611, generally follow Section 414 of the 1956 Act, but have been modernized to take into account electronic communications. 8. Section 103 preserves the ability of the Act to reflect later amendments of specified federal statutes and rules to the extent they are preemptive or this is otherwise permitted by state law. All involved in the drafting of this new Act owe a particular debt of gratitude to Richard B. Smith, who served as our chair. His efforts were pivotal to the initiation of this project. His indefatigable leadership and high standards immeasurably improved the final Act. 8. Uniform Securities Act legislative note: each state, the District of Columbia, Guam, and Puerto Rico have enacted an Administrative Procedure Act. The procedural provisions of the Act in some instances are intended to augment the State Administrative Procedure Act. In so doing, this Act differs from other uniform acts promulgated by the National Conference of Commissioners on Uniform State Laws, NCUSLO, in that it contains procedural provisions on topics such as administrative rulemaking and adjudication, service of process, judicial review of administrative adjudications, public records, public hearings, and use immunity. Normally a uniform act promulgated by NCUSLO defers to existing state procedural provisions on such matters. This act reflects a policy decision that these matters should be addressed in this act to promote uniformity in securities regulation. When a conflict exists between this act and a State Administrative Procedure Act, this act is intended to supersede the State Administrative Procedure Act. When, however, a reference is made in this Act to the State Administrative Procedure Act, this Act is intended to follow the state's existing Administrative Procedure Act. In general, in this Act a rule will apply generally and an order will apply to a specific individual, transaction, or matter, although the term order may also apply generally in those states that permit orders of general applicability. 9 Article 1 General Provisions Section 101. Short title. This Act may be cited as the Uniform Securities Act, 2002. Section 102. Definitions. In this Act, unless the context otherwise requires, 1. Administrator means the insert title of administrative agency or official. 2. Agent means an individual, other than a broker-dealer, who represents a broker-dealer in effecting or attempting to effect purchases or sales of securities or represents an issuer in effecting or attempting to effect purchases or sales of the issuer's securities. But a partner, officer, or director of a broker-dealer or issuer, or an individual having a similar status or performing similar functions is an agent only if the individual otherwise comes within the term. The term does not include an individual excluded by rule adopted or order issued under this Act. 3. Bank means, a banking institution organized under the laws of the United States, b. a member bank of the Federal Reserve System, c. any other banking institution, whether incorporated or not, doing business under the laws of a state or of the United States, a substantial portion of the business of which consists of receiving deposits or exercising fiduciary powers similar to those permitted to be exercised by national banks under the authority of the controller of the currency. Pursuant to Section 1 of 10 Public Law 87-722, 12 U.S.C. Section 92A, and which is supervised and examined by a state or federal agency having supervision over banks, and which is not operated for the purpose of evading this Act, and d. a receiver, conservator, or other liquidating agent of any institution or firm included in subparagraph a, b, or c. 4. Broker-dealer means a person engaged in the business of effecting transactions in securities for the account of others or for the person's own account. The term does not include a. an agent, b. an issuer, c. a bank or savings institution if its activities as a broker-dealer are limited to those specified in subsections 3, a, 4, b, I, through 6, 8, through x, and 11, if limited to unsolicited transactions, 3, a, 5, b, and 3, a, 5, c, of the Securities Exchange Act of 1934, 15 U.S.C. Section 78C, a, 4, and 5, or a bank that satisfies the conditions described in subsection 3, a, 4, e, of the Securities Exchange Act of 1934, 15 U.S.C. Section 78C, a, 4, d, an international banking institution, or, e, a person excluded by rule adopted or order issued under this Act. 5. Depository institution means, a bank, or, b, a savings institution, trust company, credit union, or similar institution that is organized or chartered under the laws of a state or of the United States, authorized to receive deposits, and supervised and examined by an official or agency of a state or the United States if its deposits or share accounts are insured to the maximum amount authorized by statute by the 11 Federal Deposit Insurance Corporation, the National Credit Union Share Insurance Fund, or a successor authorized by federal law. The term does not include, an insurance company or other organization primarily engaged in the business of insurance, 2. a Morris Plan Bank, or, 3. an industrial loan company. 6. Federal Covered Investment Advisor means a person registered under the Investment Advisors Act of 1940. 7. Federal Covered Security means a security that is, or upon completion of a transaction will be, a covered security under Section 18, b, of the Securities Act of 1933, 15 U.S.C. Section 77R, b, or rules or regulations adopted pursuant to that provision. 8. Filing means the receipt under this act of a record by the administrator or a designee of the administrator. 9. Fraud, deceit, and defraud are not limited to common law deceit. 10. Guaranteed means guaranteed as to payment of all principal and all interest. 11. Institutional investor means any of the following, whether acting for itself or for others in a fiduciary capacity: a. A depository institution or international banking institution; b. An insurance company; c. A separate account of an insurance company; d. An investment company as defined in the Investment Company Act of 1940; e. A broker-dealer registered under the Securities Exchange Act of 1934; 12. F. An employee pension, profit sharing, or benefit plan if the plan has total assets in excess of $10 million or its investment decisions are made by a named fiduciary, as defined in the Employee Retirement Income Security Act of 1974, that is a broker-dealer registered under the Securities Exchange Act of 1934, an investment advisor registered or exempt from registration under the Investment Advisors Act of 1940, an investment advisor registered under this act, a depository institution, or an insurance company; g. A plan established and maintained by a state, a political subdivision of a state, or an agency or instrumentality of a state or a political subdivision of a state for the benefit of its employees, if the plan has total assets in excess of $10 million or its investment decisions are made by a duly designated public official or by a named fiduciary, as defined in the Employee Retirement Income Security Act of 1974, that is a broker-dealer registered under the Securities Exchange Act of 1934, an investment advisor registered or exempt from registration under the Investment Advisors Act of 1940, an investment advisor registered under this act, a depository institution, or an insurance company; h. A trust, if it has total assets in excess of $10 million, its trustee is a depository institution, and its participants are exclusively plans of the types identified in subparagraph f, or g, regardless of the size of their assets, except a trust that includes as participants self-directed individual retirement accounts or similar. Self-directed plans, I, an organization described in Section 501, c. 3, of the Internal Revenue Code, 26 U.S.C. Section 501, c. 3, corporation, Massachusetts trust or similar business trust, limited liability company, or partnership, not formed for the specific purpose of acquiring the securities offered, with total assets in excess of $10 million. 13. J. A small business investment company licensed by the Small Business Administration under Section 301, c. of the Small Business Investment Act of 1958, 15 U.S.C. Section 681, c. with total assets in excess of $10 million, k. A private business development company as defined in Section 202, a. 22, of the Investment Advisors Act of 1940, 15 U.S.C. Section 80b2, a. 22, with total assets in excess of $10 million, l. A federal covered investment advisor acting for its own account, m. A qualified institutional buyer as defined in Rule 144a, a. 1, other than Rule 144a, a. 1, h, adopted under the Securities Act of 1933, 17 CFR 230.144a, n, a major U.S. institutional investor as defined in Rule 15a6, b. 4, I, adopted under the Securities Exchange Act of 1934, 17 CFR 240.15a6, o, any other person, other than an individual, of institutional character with total assets in excess of $10 million not organized for the specific purpose of evading this act, or, p. any other person specified by rule adopted or order issued under this act. 12. Insurance company means a company organized as an insurance company whose primary business is writing insurance or reinsuring risks underwritten by insurance companies and which is subject to supervision by the insurance commissioner or a similar official or agency of a state. 13. Insured means insured as to payment of all principal and all interest. 14. International banking institution means an international financial institution of which the United States is a member and whose securities are exempt from registration under the Securities Act of 1933. 15. Investment advisor means a person that, for compensation, engages in the business of advising others, either directly or through publications or writings, as to the value of securities or the advisability of investing in, purchasing, or selling securities, or that, for compensation and as a part of a regular business, issues or promulgates analyses or reports concerning securities. The term includes a financial planner or other person that, as an integral component of other financially related services, provides investment advice to others for compensation as part of a business, or that holds itself out as providing investment advice to others for compensation. The term does not include a. an investment advisor representative, b. a lawyer, accountant, engineer, or teacher whose performance of investment advice is solely incidental to the practice of the person's profession, c. a broker-dealer or its agents whose performance of investment advice is solely incidental to the conduct of business as a broker-dealer and that does not receive special compensation for the investment advice, d. a publisher of a bona fide newspaper, news magazine, or business or financial publication of general and regular circulation, e. a federal covered investment advisor, f. a bank or savings institution, g. any other person that is excluded by the Investment Advisors Act of 1940 from the definition of investment advisor, or h. any other person excluded by rule adopted or order issued under this act. 16. Investment advisor representative means an individual employed by or associated 15 with an investment advisor or federal covered investment advisor and who makes any recommendations or otherwise gives investment advice regarding securities, manages accounts or portfolios of clients, determines which recommendation or advice regarding securities should be given, provides investment advice or holds herself or himself out as providing investment advice, receives compensation to solicit, offer, or negotiate for the sale of or for selling investment advice, or supervises employees who perform any of the foregoing. The term does not include an individual who, a. performs only clerical or ministerial acts, b. is an agent whose performance of investment advice is solely incidental to the individual acting as an agent and who does not receive special compensation for investment advisory services, c. is employed by or associated with a federal covered investment advisor, unless the individual has a place of business in this state as that term is defined by rule adopted under Section 203A of the Investment Advisors Act of 1940, 15 U.S.C. Section 80B3A, and is, I, an investment advisor representative as that term is defined by rule adopted under Section 203A of the Investment Advisors Act of 1940, 15 U.S.C. Section 80B3A, or, 2, not a supervised person as that term is defined in Section 202A, 25, of the Investment Advisors Act of 1940, 15 U.S.C. Section 80B2A, 25, or, d, is excluded by rule adopted or order issued under this Act. 17. Issuer means a person that issues or proposes to issue a security, subject to the following: a. the issuer of a voting trust certificate, collateral trust certificate, certificate of 16 deposit for a security, or share in an investment company without a board of directors or individuals performing similar functions is the person performing the acts and assuming the duties of depositor or manager pursuant to the trust or other agreement or instrument under which the security is issued. b. the issuer of an equipment trust certificate or similar security serving the same purpose is the person by which the property is or will be used or to which the property or equipment is or will be leased or conditionally sold or that is otherwise contractually responsible for assuring payment of the certificate. c. the issuer of a fractional undivided interest in an oil, gas, or other mineral lease or in payments out of production under a lease, right, or royalty is the owner of an interest in the lease or in payments out of production under a lease, right, or royalty, whether whole or fractional, that creates fractional interests for the purpose of sale. 18. Non-issuer transaction or non-issuer distribution means a transaction or distribution not directly or indirectly for the benefit of the issuer. 19. Offer to purchase includes an attempt or offer to obtain, or solicitation of an offer to sell, a security or interest in a security for value. The term does not include a tender offer that is subject to Section 14, d, of the Securities Exchange Act of 1934, 15 U.S.C. 78 N, d. 20. Person means an individual, corporation, business trust, estate, trust, partnership, limited liability company, association, joint venture, government, governmental subdivision, agency or instrumentality, public corporation, or any other legal or commercial entity. 21. Place of business of a broker-dealer, an investment advisor, or a federal covered investment advisor means. 17. A. An office at which the broker-dealer, investment advisor, or federal covered investment advisor regularly provides brokerage or investment advice or solicits, meets with, or otherwise communicates with customers or clients, or b. Any other location that is held out to the general public as a location at which the broker-dealer, investment advisor, or federal covered investment advisor provides brokerage or investment advice or solicits, meets with, or otherwise communicates with customers or clients. 22. Predecessor Act means the act repealed by Section 702. 23. Price amendment means the amendment to a registration statement filed under the Securities Act of 1933 or, if an amendment is not filed, the prospectus or prospectus supplement filed under the Securities Act of 1933 that includes a statement of the offering price, underwriting and selling discounts or commissions, amount of proceeds, conversion rates, call prices, and other matters dependent upon the offering price. 24. Principal place of business of a broker-dealer or an investment advisor means the executive office of the broker-dealer or investment advisor from which the officers, partners, or managers of the broker-dealer or investment advisor direct, control, and coordinate the activities of the broker-dealer or investment advisor. 25. Record, except in the phrases of record, official record, and public record, means information that is inscribed on a tangible medium or that is stored in an electronic or other medium and is retrievable in perceivable form. 26. Sale includes every contract of sale, contract to sell, or disposition of, a security or interest in a security for value, and offer to sell includes every attempt or offer to dispose of, or solicitation of an offer to purchase, a security or interest in a security for value. Both terms 18 include, a security given or delivered with, or as a bonus on account of, a purchase of securities or any other thing constituting part of the subject of the purchase and having been offered and sold for value, b. a gift of assessable stock involving an offer and sale, and c. a sale or offer of a warrant or right to purchase or subscribe to another security of the same or another issuer and a sale or offer of a security that gives the holder a present or future right or privilege to convert the security into another security of the same or another issuer, including an offer of the other security. 27. Securities and Exchange Commission means the United States Securities and Exchange Commission. 28. Security means a note, stock, treasury stock, security future, bond, debenture, evidence of indebtedness, certificate of interest or participation in a profit-sharing agreement, collateral trust certificate, pre-organization certificate or subscription, transferable share, investment contract, voting trust certificate, certificate of deposit for a security, fractional undivided interest in oil, gas, or other mineral rights, put, call, straddle, option, or privilege on a security. Certificate of deposit, or group, or index of securities, including an interest therein or based on the value thereof, put, call, straddle, option, or privilege entered into on a national securities exchange relating to foreign currency, or, in general, an interest or instrument commonly known as a security, or a certificate of interest or participation in, temporary or interim certificate for, receipt for, guarantee of, or warrant or right to subscribe to or purchase, any of the foregoing. The term, 19a, includes both a certificated and an uncertificated security. b. Does not include an insurance or endowment policy or annuity contract under which an insurance company promises to pay a fixed or variable sum of money either in a lump sum or periodically for life or other specified period. c. Does not include an interest in a contributory or non-contributory pension or welfare plan subject to the Employee Retirement Income Security Act of 1974. d. Includes as an investment contract an investment in a common enterprise with the expectation of profits to be derived primarily from the efforts of a person other than the investor, and a common enterprise means an enterprise in which the fortunes of the investor are interwoven with those of either the person offering the investment, a third party, or other investors, and e. includes as an investment contract, among other contracts, an interest in a limited partnership and a limited liability company and an investment in a viatical settlement or similar agreement. 29. Self-regulatory organization means a national securities exchange registered under the Securities Exchange Act of 1934, a national securities association of broker-dealers registered under the Securities Exchange Act of 1934, a clearing agency registered under the Securities Exchange Act of 1934, or the Municipal Securities Rulemaking Board established under the Securities Exchange Act of 1934. 30. Sign means, with present intent to authenticate or adopt a record, a. to execute or adopt a tangible symbol, or b. to attach or logically associate with the record an electronic symbol, sound, or 20 process. 31. State means a state of the United States, the District of Columbia, Puerto Rico, the United States Virgin Islands, or any territory or insular possession subject to the jurisdiction of the United States. Official comments. Prior provisions, 1956 Act Section 401, RUSA 101. 1. Under Section 605, a. The administrator has the power to define by rule any term, whether or not used in this Act, as long as the definitions are not inconsistent with the Act. 2. All definitions include corresponding meanings. For example, filing would include file or filed, sale would include sell. 3. Prefatory phrase, in this Act, unless the context otherwise requires. Prior provisions, 1956 Act Section 401 Preface, RUSA Section 101 Preface. This prefatory phrase, which is in the counterpart provisions of the federal securities statutes, c. e.g., Securities Act of 1933 Section 2, a. provides the basis for the courts to take into account the statutory and factual context of each definition, c. e.g., Reeves v. Ernst & Young, 494 U.S. 56, 1990, 2. Lewis Loss and Joel Seligman, Securities Regulation 927-929, 3D ed. Rev. 1999, and will allow the courts to harmonize this Act's definitions with the counterpart federal securities definitions to the extent appropriate. Cf. Aiken v. QLINV, Inc., 959 F.2 D 521, 532, 5th Sir 1992. Texas courts generally look to decisions of the federal courts to interpret the Texas Securities Act because of obvious similarities between the state and federal laws. Cook v. Cook Industry, Inc. 203 F.3 D 1202, 1235, 10th Sir 2000, following federal definition of materiality, Biles v. Young, 432 S.E.2 D 482, 484, SC 1993, Section 35-1-1490, 2, is substantially similar to Section 12(1) of the Federal Securities Act. 4. Section 102, 2 Agent, Prior Provisions, 1956 Act Section 401, b. RUSA Section 101, 14. Section 102, 2, in part,
follows the 1956 Act definition. The 1956 Act used the term agent while the RUSA's Section 101(14) used the term sales representative. Given the broader enactment of the 1956 Act, this Act also uses the term agent. Certain exclusions from the 1956 Act are exemptions in this Act. See Section 402(b). Whether a particular individual who represents a broker-dealer or issuer is an agent depends upon much the same factors that create an agency relationship at common law. See, e.g., Norwest Bank Hastings v. Clapp, 394 N.W.2d 176, 179, Minnesota CT App 1986. Following official comment that establishing agency under the Uniform Securities Act depends upon much the same factors which create an agency relationship at common law, Shaughnessy and 21 Co., Inc. v. Commissioner of Seconds, 1971-1978 Blue Sky L. Republic, CCH, 71,348, Wisconsin Sir CT 1977, unlicensed person who took information relevant to securities transactions and turned it over to securities agents was himself an agent. An individual can be an agent for a broker-dealer or issuer for a purpose other than effecting or attempting to effect purchases or sales of securities and not be a statutory agent under this Act. See, e.g., Baker, Watts & Co. v. Miles and Stockridge, 628.2d 356, 367, MDCT App 1993, attorney-client relationship is generally one of agency, but that alone does not bring an attorney within Securities Act definition of agent. An individual will not be an agent under Section 102(2), because of the person's status as a partner, officer, or director of a broker-dealer or issuer if such an individual does not effect or attempt to effect purchases or sales of securities. See, e.g., Abel v. Potomac INS Co., 858 F.2d 1104, 5th Sir 1988. Section 102(2) is intended to include any individual who acts as an agent, whether or not the individual is an employee or independent contractor. C.F. Hollinger v. Titan Capital Corp., 914 F.2d 1564, 9th Sir and Bank 1990, Cert. Denied, 499 U.S. 976, 1991. The word individual in the definition of the term agent is limited to human beings and does not include a juridical person such as a corporation. Cf. definition of person in Section 102(20). The 1956 Act Section 401(b) similarly was limited to individuals and did not include juridical persons. See, e.g., Connecticut National Bank v. Jacomai, 699 A.2d 101, 111-112, Con 1997, agent only includes natural persons when it used the term individual, Schpock v. Fodale, 236 N.W.2d 97, 99, Michigan CT App 1975, agent defined to be individual and did not include a corporation. An individual whose acts are solely clerical or ministerial would not be an agent under Section 102(2). Cf. Section 402(b), 8. Ministerial or clerical acts might include preparing written communications or responding to inquiries. 5. Section 102(3) Bank, prior provision, subsection 3, a, 6, of the Securities Exchange Act of 1934. A United States branch of a foreign bank that otherwise satisfies this definition would be a bank. 6. Section 102(4) Broker-dealer, prior provisions, 1956 Act Section 401, c. RUSA's Section 101(2). This definition generally follows the definition of broker-dealer in the 1956 Act and RUSA. The use of the compound term is meant to include either a broker or a dealer. The recognized distinction is that a broker acts for the benefit of another while a dealer acts for itself in buying for or selling securities from its own inventory.
The distinction between a person engaged in the business of effecting transactions in securities and an investor, who may buy and sell with some frequency and is outside the scope of this term, has been well developed in the case law. C6 Lewis Loss and Joel Seligman, Securities Regulation 2980-2984, 3d ed. 1990. 22 The 1956 Act Section 401, c. excluded from the definition of broker-dealer a person who during any 12 consecutive months did not direct more than 15 offers to buy or sell in this state. In this Act, exemptions from broker-dealer registration are provided in Section 401, b. The Gramm-Leach-Bliley Act, signed into law in November 1999, rescinded the blanket exemption of banks from the definition of broker and dealer in Sections 3a, 4, and 5 of the Securities Exchange Act of 1934. The Gramm-Leach-Bliley Act permits a bank to avoid registration as a broker or dealer at the federal level if the bank limits its activities to those specified in the Securities Exchange Act. This act generally adopts the activity-focused exceptions for banks included in the Gramm-Leach-Bliley Act, with minor modifications relating to the private placement and to minimize brokerage activities of banks, 15 U.S.C. 78c, a, 4, b, 7, and 11. This act also reaches savings institutions. A state may decide to adopt an exclusion in Section 102, 4, c, that fully conforms with the bank exceptions contained in the Gramm-Leach-Bliley Act. For states that choose this approach, the language of Section 102, 4, c, should read, c. A bank or savings institution if its activities as broker-dealer are limited to those specified in Section 3a, 4, and 3a, 5, of the Securities Exchange Act of 1934, 15 U.S.C. Section 78c, a, 4, and 5, or a bank that satisfies the conditions specified in Section 3a, 4, e, of the Securities Exchange Act of 1934, 15 U.S.C. 78c, a, 4. Section 102, 4, e, of this Act also permits a securities administrator to adopt additional exclusions that exclude banks and other depository institutions, in whole or in part, from the definition of broker-dealer. States that promptly adopt this Act should consider whether it is appropriate to provide banks a transition period to comply with the Act's new activity-focused exceptions. The activity-focused exceptions for banks in the Gramm-Leach-Bliley Act were originally to become effective at the federal level on May 12, 2001. However, the Securities and Exchange Commission has delayed the effective date of these activity-focused exceptions and thus continued the blanket exemption for banks beyond May 12, 2001, and commenced a rulemaking designed to clarify and define the scope of the bank exceptions in the Gramm-Leach-Bliley Act. See Secretary Ex Act Rels. 44291, 74 SEC Doc. 2155, 2001, Proposal, 45897, 77 SEC Doc. 1555, 2002, Proposal. To avoid disrupting the activities of banks, states should consider delaying implementation of the activity-focused exceptions in this Act until these exceptions are implemented at the federal level. Section 15, H. 1, of the Securities Exchange Act of 1934, as amended by the National Securities Markets Improvement Act of 1996, preempts state law from establishing capital, custody, margin, financial responsibility, making and keeping records, bonding, or financial or operational reporting requirements for brokers, dealers, municipal securities dealers, government securities brokers, or government securities dealers that differ from, or are in addition to the 23 requirements in those areas established under the Securities Exchange Act. These preemptions are recognized in the substantive broker-dealer provisions in Article 4. 7 Section 102, 5 Depository Institution, no prior provision. A depository institution's securities are addressed by the exemption in Section 201, 3. A depository institution is an institutional investor in Section 102, 11, a. 8 Section 102, 6 Federal Covered Investment Advisor, no prior provision. This provision is necessitated by Section 203A of the Investment Advisors Act of 1940, added by Title III of the National Securities Markets Improvement Act of 1996, which allocates to primary state regulation most advisors with assets under management of less than $25 million. SEC registration is permitted, but not required, for investment advisors having between $25 and $30 million of assets under management, and is required of investment advisors having at least $30 million of assets under management. Investment Advisors Act of 1940 Rule 203A1. Most advisors with assets under management of $25 million or more register solely under Section 203 of the Investment Advisors Act of 1940 and not state law. This division of labor is intended to eliminate duplicative regulation of investment advisors. 9 Section 102, 7 Federal Covered Security, no prior provision. The National Securities Markets Improvement Act of 1996, as subsequently amended, partially preempted state law in the securities offering and reporting areas. Under Section 18A of the Securities Act of 1933, no state statute, rule, order, or other administrative action may apply to 1. The registration of a covered security or a security that will be a covered security upon completion of the transaction, 2. A. Any offering document prepared by or on behalf of the issuer of a covered security, 2. B. Any proxy statement, report to shareholders, or other disclosure document relating to a covered security or its issuer that is required to be filed with the SEC or any National Securities Association registered under Section 15A of the Securities Exchange Act, such as the National Association of Securities Dealers, NASD, or 3. The merits of a covered security or a security that will be a covered security upon completion of the transaction. Section 18B of the Securities Act of 1933 applies to 4 types of covered securities. 1. Securities listed or authorized for listing on the New York Stock Exchange, NYSE, the American Stock Exchange, Amex, the national market system of the Nasdaq stock market, or securities exchanges registered with the Securities and Exchange Commission, SEC, or any tier or segment of their trading, if the SEC determines by rule that their listing standards are substantially similar to those of the NYSE, Amex, or Nasdaq National Market System, which the 24 SEC has done through Rule 146, and any security of the same issuer that is equal in seniority or senior to any security listed on the NYSE, Amex, or Nasdaq National Market System. 2. Securities issued by an investment company registered with the SEC, or one that has filed a registration statement under the Investment Company Act of 1940. 3. Securities offered or sold to qualified purchasers. This category of covered securities will become operational when the SEC defines the term qualified purchaser as used in Section 18b. 3 of the Securities Act of 1933, by rule. To date, the SEC has proposed, but not adopted, Rule 146c of the Securities Act of 1933, and 4. Securities issued under the following specified exemptions of the Securities Act of 1933, a. Sections 4, 1. Transactions by persons other than an issuer, underwriter, or dealer, and 4. 3. Dealers after specified periods of time, but only if the issuer files reports with the Commission under Sections 13 or 15, d. of the Securities Exchange Act, b. Section 4, 4. Unsolicited brokerage transactions. C. Securities Act exemptions in Section 3, a, with the exception of the charitable exemption in Section 3, a, 4, the exchange exemption in Section 3, a, 10, the intrastate exemption in Section 3, a, 11, and the municipal securities exemption in Section 3, a, 2.
but only with respect to the offer or sale of such municipal security in the state in which the issuer of such security is located, and d. securities issued in compliance with SEC rules under Section 4, 2, private placements. Section 18, c. 1. Preserves state authority to investigate and bring enforcement actions with respect to fraud or deceit, or unlawful conduct by a broker or dealer, in connection with securities or securities transactions. The National Securities Markets Improvement Act, in essence, preempts aspects of the securities registration and reporting processes for specified federal covered securities. The Act does not diminish state authority to investigate and bring enforcement actions generally with respect to securities transactions. The states are authorized to require filings of any document filed with the SEC for notice purposes together with annual or periodic reports of the value of securities sold or offered to be sold to persons located in the state, if such sales data is not included in documents filed with the Commission, solely for notice purposes and the assessment of any fee, together with a consent to service of process and any required fee. Section 18, c. 2. However, no filing or fee may be required with respect to any listed security that is a covered security under Section 18, b. 1, traded on specified stock markets. Section 302 of this Act addresses notice filings and fees 25 applicable to federal covered securities. 10 Section 102, 8 Filing, Prior Provision, RUSA Section 101, 4. The RUSA definition was revised to recognize that records may be filed in paper form or electronically with the administrator, or designees such as the Web CRD, Central Registration Depository, or Investment Advisor Registration Depository, IARD, or the Securities and Exchange Commission's Electronic Data Gathering, Analysis, and Retrieval System, EDGAR, or successor systems. In the RUSA definition, the term filed referred to actual delivery of a document or application. This Act substitutes the term record, which is defined in Section 102(25), to refer broadly to information that is inscribed on a tangible medium or that is stored in an electronic or other medium and is retrievable in perishable form. This definition requires the receipt of a record. The definition does not limit filing to any specific medium such as mail, certified mail, or a particular electronic system. The definition is intended to permit an administrator to accept filings over the Internet or through a direct modem system, both of which are now used to transmit documents to EDGAR, or through new electronic systems as they evolve. Receipt refers to the actual delivery of a record to the administrator or a designee and does not refer to a subsequent examination of the record by the administrator. See, e.g., Fairman v. Blunt, 825 S.W.2d 658, MOCT App 1992. If a deficient form was provided to a designee, but not provided to the administrator because of the deficiency, it would not be filed under this definition. 11 Section 102, 9 Fraud, Deceit, and Defraud, Prior Provisions, 1956 Act Section 401, d. RUSA Section 101, 6. This definition, which is identical to the 1956 Act and RUSA, codifies the holdings that fraud as used in the federal and state securities statutes is not limited to common law deceit. See generally 7 Lewis Loss and Joel Seligman, Securities Regulation 3421-3448, 3D ed. 1991. 12 Section 102, 10 Guaranteed, Prior Provisions, 1956 Act Section 401, e. RUSA Section 401, a. 1. The 1956 Act definition of guaranteed applies generally to payment of principal, interest, or dividends. The RUSA definition of guaranteed, which was solely applicable to exempt securities, applied to the guarantee of all or substantially all of principal and interest or dividends. Section 102, 10, follows the 1956 Act approach and applies generally to the guarantee of all principal and all interest. Any method of guarantee that results in a guarantee of payment of all principal and all interest will suffice, including, for example, an irrevocable letter of credit.
This definition does not address whether or not a guarantee, whether whole or partial, is itself a security. That issue is addressed by the definition of security in section 102, 28. 2613. Section 102, 11 Institutional Investor, Prior Provisions, RUSA Section 101, 5, Securities Act of 1933 Rules 144A and 501A. Sections 102, 11, A, through, K, are based on Rule 501A, of the Securities Act of 1933, but do not include the paragraphs of Rule 501A, that address individuals. Given the significant period of time since Rule 501A was adopted, this act has used a $10 million minimum for several categories of institutional investor rather than $5 million minimum used in Rule 501A. Section 102, 11, H, concludes with an except clause meant to exclude self-directed plans for individuals from this definition. With respect to the exclusion of Rule 144A, A, 1, H, from Section 102, 11, M, the substance of Rule 144A, A, 1, H, appears in Section 102, 11, I, but with a requirement of total assets in excess of $10 million. Section 102, 11, O, is meant to reach persons similar to those listed in Sections 102, 11, A, through, N, but not otherwise listed. Under Section 503, if challenged in a proceeding, the burden of proving the availability of an exemption is on the person claiming it. An interpretive opinion may be sought from the administrator under Section 605, D. 14 Section 102, 12 Insurance Company, no prior provision. This definition is based on Securities Act of 1933 Section 2, A, 13. 15 Section 102, 13 Insured, prior provision, RUSA Section 401, A, 2. The RUSA definition of insured, which was solely applicable to exempt securities, applied to the insurance of all or substantially all of principal, interest, or dividends. Section 102, 13, is applicable generally but is limited to payment of all principal and all interest. 16 Section 102, 14 International Banking Institution, no prior provision. Securities issued or guaranteed by the International Bank for Reconstruction and Development, 22 U.S.C. Section 286 K1, A, the Inter-American Development Bank, 22 U.S.C. Section 283 H, A, the Asian Development Bank, 22 U.S.C. Section 285 H, A, the African Development Bank, 22 U.S.C. Section 290 I-9, and the International Finance Corporation, C 22 U.S.C. Section 282K, are treated as exempt securities under Section 3, A, 2, of the Securities Act of 1933, see generally 3 Lewis Loss and Joel. Seligman, Securities Regulation 1191-1194, 3D ed. Rev. 1999, and are within this term. 17 Section 102, 15 Investment Advisor, Prior Provisions, 1956 Act Section 401, F, RUSA Section 101, 7. This term generally follows the definition in Section 202, A, 11, of the Investment Advisors Act of 1940, but has been updated to take into account new media such as the Internet. The first sentence in Section 102, 15, is identical to the first sentence in the 1956 Act Section 27401, F, and the counterpart language in Section 202, A, 11. The RUSA definition deleted the phrases either directly or through publications or writings and regular before business. These terms have been returned to Section 102, 15, because of the intention that this definition be construed uniformly with the definition in Section 202, A, 11, of the Investment Advisors Act of 1940. This first sentence would not reach the author of a book who did not receive compensation as part of a regular business for providing investment advice. The second sentence in the term addressing financial planners is new. The purpose of this sentence is to achieve functional regulation of financial planners who satisfy the definition of investment advisor. Cf. Investment Advisors Act Release 1092, 39 SEC Doc. 494, 1987, similar approach in Securities and Exchange Commission Interpretative Release. This reference is not intended to preclude persons who hold a formally recognized financial planning or consulting designation or certification from using this designation. The use by a person of a title, designation, or certification as a financial planner or other similar title, designation, or certification alone does not require registration as an investment advisor. Sections 102, 15, A, through H, are exclusions from the term investment advisor. An excluded person can be held liable for fraud in providing investment advice, see Section 502, but would not be subject to the registration and regulatory provisions in Article 4. Sections 102, 15, A, and E, are new and recognize that investment advisor representatives and federal covered investment advisors are separately treated in this Act. See definitions in Sections 102, 6, and 102, 16, registration and exemptions in Sections 404 to 405. Sections 102, 15, B, C, and G, are substantively identical to the 1956 Act, RUSA, and the Investment Advisors Act of 1940. The official comment to the 1956 Act Section 401, F, quoted an opinion of the Securities and Exchange Commission General Counsel in Investment Advisors Act Release 2 on the meaning of special compensation included in Section 102, 15. See, this clause amounts to a recognition that brokers and dealers commonly give a certain amount of advice to their customers in the course of their regular business, and that it would be inappropriate to bring them within the scope of the Investment Advisors Act, merely because of this aspect of their business. On the other hand, that portion of Clause C, which refers to special compensation, amounts to an equally clear recognition that a broker or dealer who is specially compensated for the rendition of advice should be considered an investment advisor and not be excluded from the purview of the Act merely because he is also engaged in effecting market transactions in securities. The essential distinction to be borne in mind in considering borderline cases is the distinction between compensation for advice itself and compensation for services of another character to which advice is merely incidental. Similarly, other broker-dealer employees such as research analysts who receive no special compensation from third parties for investment advice would not be required to register as 28 investment advisors. The 1956 Act definition added the word paid in Section 401, F, 4, to the counterpart exclusion in Section 202, A, 11, of the Investment Advisors Act to emphasize, as the official comment explained, that a person who periodically distributes a tipster sheet free as a way to get paying clients is not excluded from the definition as a publisher. After the 1956 Act was published, the United States Supreme Court construed the definition of investment advisor in Lowe v. SEC, 472 U.S. 181, 1985, and concluded, Congress did not intend to exclude publications that are distributed by investment advisors as a normal part of the business of servicing their clients. The legislative history plainly demonstrates that Congress was primarily interested in regulating the business of rendering personalized investment advice, including publishing activities that are a normal incident thereto. On the other hand, Congress, plainly sensitive to First Amendment concerns, wanted to make clear that it did not seek to regulate the press through the licensing of non-personalized publishing activities. ID at 185. Responsive to this language, RUSA rewrote this exclusion to provide, a publisher, employee, or columnist of a newspaper, news magazine, or business or financial publication, or an owner, operator, or employee of a cable, radio, or television network, station, or production facility, if, in either case, the financial or business news published or disseminated is made available to the general public and the content does not consist of rendering advice on the basis of the specific investment situation of each client.
Recent experience at the federal and state level suggests that the 1956 Act and RUSA approaches may be too broad. The Retention of the Investment Advisors Act approach provides a better balance between First Amendment concerns and protection of investors from non-bona fide publicizing of investment advice. The exclusion in Section 102(15) d. is intended to exclude publishers of Internet or electronic media, but only if the Internet or electronic media publication or website satisfies the bona fide and publication of general and regular circulation requirements. CFSECV Park, 99 F sub 2D 889, 895 to 896, ND IL 2000. Court declined to dismiss complaint against an Internet website when there were allegations that the website was not bona fide or of general and regular circulation. The exclusion in Section 102(15) g. is required by the National Securities Markets Improvement Act of 1996. This exclusion will reach banks and bank holding companies as described in Investment Advisors Act Section 202(a), 11(a), and persons whose advice solely concerns United States government securities as described in Section 202(a), 11(e). 2918. Section 102(16) Investment Advisor Representative, no prior provision. Investment advisor representatives have not been required to register under the Federal Investment Advisors Act, before or after the National Securities Markets Improvement Act. The term investment advisor representative is not intended to preclude persons who hold a formally recognized financial planning or consulting title, designation, or certification from using such a designation. The use by a person of a title, designation, or certification as a financial planner, or other similar title, designation, or certification alone does not require registration as an investment advisor representative. 19 Section 102(17) Issuer, Prior Provisions, 1956 Act Section 401, g. RUSA Section 101(8). This section generally follows the 1956 Act and RUSA. In paragraph b, the phrase, or that is otherwise contractually responsible for assuring payment of the certificate is intended to address forms of payment other than leases or conditional sales contracts. It would also reach guarantors. 20 Section 102(18) Noni-Suor Transaction or Noni-Suor Distribution, Prior Provisions, 1956 Act Section 401, h, RUSA Section 101, 9. This definition is relevant to several exempt transactions in Section 202. In Technomedical Labs, Inc. v. Utah Secretary DIB, 744p.2d 320, Utah CTF 1987, the court declined to limit the term benefit to monetary benefits and instead held a spin-off transaction could provide direct or indirect benefits to an issuer. ID at 323 to 324, following SEC v. Detronics N.R., Inc., 490 F.2d 250, 4th Sir 1973, Cert. Denied, 416 U.S. 937, SEC v. Harwin Industry Corp., 326 F sub 943, SDNY 1971. In a similar fashion, transactions by officers, directors, promoters, and other insiders of the issuer may benefit the issuer and may not qualify as noni-suor transactions. 21 Section 102(19) Offer to purchase, no prior provision. A rescission offer under Section 510 would be an offer to purchase with respect to a security that earlier had been sold. 22 Section 102(20) Person, Prior Provisions, 1956 Act Section 401, I, RUSA Section 101, 10. This is the standard definition used by the National Conference of Commissioners for Uniform State Laws with the addition of limited liability company to reflect current usage. The use of the concluding phrase or any other legal or commercial entity is intended to be broad enough to include other forms of business entities that may be created or popularized in the future. 23 Section 102(21) Place of business, prior provision, Rules 203A3, b, and 222-1 of the Investment Advisors Act of 1940. 24 Section 102, 23 Price Amendment, Prior Provision, RUSA Section 101, 11. A Price 30 amendment may be used in a registration coordinated with the Securities and Exchange Commission procedure in Section 303, d. In the case of non-cash offerings, required information concerning such matters as the offering price and underwriting arrangements is normally filed in a price amendment after the rest of the registration statement has been reviewed by the Securities and Exchange Commission staff. See Generally 1 Lewis Loss and Joel Seligman, Securities Regulation 542-550, 3D ed. Rev. 1998. 25 Section 102, 24 Principal Place of Business, Prior Provision, Rule 222-1, b, of the Investment Advisors Act of 1940. 26 Section 102, 25 Record, Prior Provision, Uniform Electronic Transactions Act Section 2, 13. Cf. Section 3, a, 37, of the Securities Exchange Act of 1934. The Uniform Electronic Transactions Act 2, 13, defines record in nearly identical terms. The official comment explains, this is a standard definition designed to embrace all means of communicating or storing information except human memory. It includes any method for storing or communicating information, including writings. A record need not be indestructible or permanent, but the term does not include oral or other communications which are not stored or preserved by some means. This term is intended to embrace new forms of records that are created or popularized in the future. A record would include, but not be limited to, a registration statement, report, application, book, publication, account, paper, correspondence, memorandum, agreement, document, computer file, or disk, microfilm, photograph, or audio or visual tape. 27 Section 102, 26 Sale, Prior Provisions, 1956 Act Section 401, J, RUSA Section 101, 13. Both the 1956 Act and RUSA definition of sale are modeled on Section 2, A, 3, of the Securities Act of 1933. Language in Section 401, J, of the 1956 Act addressed the now rescinded SEC no-sale doctrine and has been eliminated. Merger transactions are usually sales under Section 102, 26, but may be exempted from the securities registration requirements by Section 202, 18. 28 Section 102, 28 Security, Prior Provisions, 1956 Act Section 401, 1, RUSA Section 101, 16. Much of the definition in Section 102, 28, like the definitions in the 1956 Act Section 401, L, and RUSA Section 101, 16, is identical to the definition in Section 2, A, 1, of the Securities Act. State courts interpreting the Uniform Securities Act definition of security have often looked to interpretations of the federal definition of security. See Generally 2 Lewis Loss and Joel Seligman, Security Regulation 923-1138.19, 3D ed. Rev. 1999. The most recent amendments to Section 2, A, 1, of the Securities Act of 1933 were added by the Commodities Futures Modernization Act of 2000, which added or revised language in the 31 Securities Act addressing security futures and securities puts, calls, straddles, options, or privileges. Identical language has been included in Section 102, 28, of this Act to harmonize interpretation of the federal and state definition of a security. With respect to a security futures product, Section 28, A, of the Securities Exchange Act of 1934, as amended by the Commodity Futures Modernization Act of 2000, further provides, no provision of any state law regarding the offer, sale, or distribution of securities shall apply to any transaction in a security futures product,
except that this sentence shall not be construed as limiting any state anti-fraud law of general applicability. Pre-organization certificates or subscriptions are included in this term, obviating the need for a separate definition as was included in RUSA Section 402.13. Section 102.28 uses RUSA's fractional undivided interest in oil, gas, or other mineral rights formulation, which originated in Section 2(a)(1) of the Securities Act of 1933, rather than the 1956 Act formulation, certificate of interest or participation in an oil, gas, or mining title. In recent years, courts interpreting Section 2(a)(1) of the Securities Act of 1933 have found certain oil, gas, or mineral rights to be investment contracts, that is, securities. 2 Lewis Loss and Joel Seligman, Securities Regulation 979-982, 3D ed. Rev. 1999. A new sentence was added in Section 102.28a, referring to certificated or uncertificated securities to indicate that the term is intended to apply whether or not a security is evidenced by a writing. Section 102.28a is intended to reject Thomas v. State of Texas, 65 S.W.3D38, Texas ERIM App 2001. Under Texas law, evidence of indebtedness requires a writing. Insurance or endowment policies or endowment or annuity contracts, other than those on which an insurance company promises to make variable payments, are excluded from this term. Variable insurance products are also excluded in many states and are exempted from securities registration in others under provisions such as Section 201(4). When variable products are included in the definition of security and exempted from registration, state securities administrators can bring enforcement actions concerning variable insurance sales practices. The drafting committee recognized that the decision whether to exclude variable annuities from the definition of security will be made on a state-by-state basis. Those states which intend to exclude variable products from the definition of security should add the words "or variable" to Section 102.28. B, so that it will read, B. The term does not include an insurance or endowment policy or annuity contract under which an insurance company promises to pay a fixed or variable sum of money either in a lump sum or periodically for life or other specified period. In the view of the American Council of Life Insurers, the brackets around the words "or variable" should be removed to follow the 32 majority of jurisdictions. 37 jurisdictions including Guam currently exclude all insurance, endowment, and annuity contracts from the definition of security. Removal of the brackets around the words "or variable," therefore, would incorporate the approach taken in the majority of jurisdictions. The removal of these brackets also prevents a statutory conflict with up to 48 jurisdictions that grant the insurance commissioner exclusive jurisdiction to regulate the issuance and sale of variable contracts. Moreover, this approach recognizes that the issuance and sale of variable contracts is comprehensively regulated by the Securities and Exchange Commission, the National Association of Securities Dealers, 50 state insurance departments, and in the case of group life and annuities, the Department of Labor. Like all other financial products, this approach imposes only one, rather than two, levels of regulation in each state and reflects the philosophy of financial services modernization. In the view of the North American Securities Administrators Association, variable products should be exempted from registration, not excluded from the definition of securities. One of the goals of this act is to align state and federal law. The United States Supreme Court ruled that a variable annuity is a security in SEC v. Variable Annuity Life Insurance Company of America, 359 U.S. 65, 1959. More recently, it has been confirmed that variable insurance products are covered securities as defined in the National Securities Markets Improvement Act of 1996, NSMIA, and in the Securities Litigation Uniform Standards Act of 1998, SLUSA, see Lander v. Hartford Life Annuity INS, 251 F.3d 101, 2d Sir 2001. When variable products are included in the definition of security and exempted from registration, State securities administrators can bring enforcement actions concerning variable insurance sales practices. This approach toward functional regulation is supported by the National Association of Securities Dealers as evidenced by a February 2001 letter from Mary Scapiro, President of Regulatory Policy and Oversight. Based on our experience, we have found that variable products sales-related problems parallel those of mutual funds and other securities. Because of the substantial similarities between variable contracts and other securities products, we believe it is incongruous for agents and sales practices involved in variable annuities not to be covered by state securities laws. State securities regulators support the functional regulation of agents because, 1. Insurance companies are not affected since state securities regulators are preempted from requiring the registration of variable products. 2. The vast majority of broker-dealer subsidiaries of insurance companies are already registered to sell securities in most states. And 3. The vast majority of agents are already dually licensed to sell insurance and securities in most states. Section 102(28) C. includes the exclusion in RUSA from the 1956 definition of security for 33 an interest in a contributory or non-contributory pension or welfare plan subject to the Employee Retirement Income Security Act of 1974. The first clause in Section 102(28) D. is derived from the leading case of SEC v. W.J. Howico, 328 U.S. 293, 1946, which has been widely followed by federal and state courts. The second clause in Section 102(28) D. is based, in part, on the leading case of SEC v. Glenn W. Turner Enter, Inc., 474 F.2 D 476, 482 N.7, 9th Sir 1973, Cert. Denied, 419 U.S. 900, 1974. The courts have divided over the interpretation of the common enterprise element of an investment contract. The courts generally recognize that horizontal commonality, for example, the pooling of an investment by two or more investors, is a common enterprise. A small minority of the federal circuits will also find a common enterprise in a vertical relationship when a single investor is dependent upon the expertise of a single commodities broker. Since two or more persons do not share in the profitability of an undertaking, it is difficult to argue that there is a common enterprise. Section 102(28) D. follows a significantly larger number of federal circuits and adopts a more restrictive form of vertical commonality that occurs only when there is profit sharing between two persons, even if, for example, one is a conventional investor and one is a promoter. See generally 2 Lewis Loss and Joel Seligman, Securities Regulation 989-997, 3D ed. Revelation 1999. In interpreting all elements of the investment contract, the courts have emphasized substance, not form. A conventional partnership involving two individuals who actively participate in its management and who each own 50% interest of its profits has consistently not been viewed as an investment contract because profits do not come from the efforts of others. On the other hand, investments in limited partnership interests which are traded on stock exchanges consistently have been held to be investment securities because profits do come substantially from the efforts of others. Indeed, interests in an entity called a general partnership may be a security when the general partnership functions like a limited partnership. See, e.g., Williamson v. Tucker, 645 F.2 D 404, 424, 5th Sir 1981, Cert. Denied, 454 U.S. 897, 1981, see generally 2 Loss and Seligman, Supra, at 1019-1033. Section 102(28) E. is consistent with state and federal securities laws which have recognized interests in limited liability companies and limited partnerships in some circumstances as securities. See 2 Lewis Loss and Joel Seligman, Securities Regulation 1028-1031, 3D ed. Rev. 1999, when consistent with the court decisions interpreting the investment contract concept. This act also refers to an investment in a viatical settlement or a similar agreement to make unequivocally clear that viatical settlement and similar agreements, which otherwise satisfy the definition of an investment contract, are securities. This is intended to reject the holding of one court that a viatical contract could not be a security. See SEC v. Life Partners Incorporated, 87 F.3 D 536, D.C. Sir 1996, Regi denied, 102 F.3 D 587, D.C. Sir 1996. A number of states have done so by statute. Judicial construction of the term investment contract has been the most frequently litigated 34 issue concerning the term security. See Gabaldon, A Sense of Security, an Empirical Study, 25 J Corp L 307, 2000, explaining that there had been 792 cases decided to that date in which the definition of a security played a prominent role. ID at 308. Some 461 of the 792 cases, 58%, concerned investment contracts. ID at 322. A number of states, by statute, rule, or case law have also adopted the risk capital test to find a security when an investment is subject to the risks of an enterprise with the expectation of profit or other valuable benefit and the investor has no direct control over the management of the enterprise. See, e.g., to Loss and Seligman, Supra, at 939 to 940 N.50. 29 Section 102, 29 Self-Regulatory Organization, Prior Provision, RUSA Section 101, 17. This definition was added by RUSA and is based on a counterpart provision in the American Law Institute Federal Securities Code. At the current time, national securities exchanges are registered under Section 6 of the Securities Exchange Act of 1934, national securities associations under Section 15A, clearing agencies under Section 17A, and the Municipal Securities Rulemaking Board under Section 15B. 30 Section 102, 30 Sign, no prior provision. This definition is intended to facilitate electronic signatures, to the extent permitted by Section 105. 31 Section 102, 31 State, Prior Provisions, 1956 Act Section 401, M, RUSA Section 101, 18. This is the standard definition used by the National Conference of Commissioners on Uniform State Laws. It does include territories and possessions of the United States, as well as the District of Columbia and Puerto Rico, but does not include foreign governments, their territories, or their possessions. In this act, foreign always refers to activity, a government, or person outside of the United States, not a different state within the United States. Section 103. References to federal statutes. Securities Act of 1933, 15 U.S.C. Section 77A ETSEQ, Securities Exchange Act of 1934, 15 U.S.C. Section 78A ETSEQ, Public Utility Holding Company Act of 1935, 15 U.S.C. Section 79 ETSEQ, Investment Company Act of 1940, 15 U.S.C. Section 80A1 ETSEQ, Investment Advisors Act of 1940, 15 U.S.C. Section 80B1 ETSEQ, Employee Retirement Income Security Act of 1974, 29 U.S.C. Section 1001 ETSEQ, National Housing Act, 12 U.S.C. Section 1701 ETSEQ, Commodity Exchange Act, 7 U.S.C. Section 1 ETSEQ, Internal Revenue Code, 26 U.S.C. Section 1 ETSEQ, Securities Investor Protection Act of 1970, 15 U.S.C. Section 78AAA ETSEQ, Securities 35 Litigation Uniform Standards Act of 1998, 112 STAT 3227, Small Business Investment Act of 1958, 15 U.S.C. Section 661 ETSEQ,
and electronic signatures in Global and National Commerce Act, 15 U.S.C. Section 7001 ETSEQ, mean those statutes and the rules and regulations adopted under those statutes, as in effect on the date of enactment of this Act, or as later amended. Official comments. Prior provisions, 1956 Act Section 401, K, RUSA Section 101, 15. 1. There are a large number of references to other laws in this Act, particularly to the federal securities laws identified in Section 103, and to rules adopted by the Securities and Exchange Commission under those laws. One of the main objectives of this Act is to take account of those provisions in the federal laws that are preemptive, and to coordinate with other, non-preemptive provisions of the federal laws where coordination between federal and state securities law is in the public interest. 2. Section 12, d, of the Uniform Statute and Rule Construction Act, adopted by Guslow in 1995, provides, a statute or rule that incorporates by reference a statute or rule of another jurisdiction does not incorporate a later enactment or adoption or amendment of the other statute or rule. Nevertheless, it is not uncommon for states to permit later amendments to statutes and rules referenced in enacted legislation to become automatically effective. In those states, the final bracketed language in this section should be included in the Act. 3. In those states which do not permit automatic effectiveness of later amendments and that follow Section 12, d, of the Uniform Statute and Rule Construction Act, this problem has been addressed by either giving the administrator the power to update by rule or the duty to notify the legislature when amendment is necessary. When the legislature notification approach is adopted, to prevent a gap period, the administrator might be given the power to act by rule until the legislature has acted. 4. After enactment, amendments to a preemptive federal statute, to rules adopted by a federal agency under a preemptive provision of a federal statute, or to amendments to such rules should be enforced in all states under the Supremacy Clause of the United States Constitution. A number of such references are in this Act. 36 Section 104. References to federal agencies. A reference in this Act to an agency or department of the United States is also a reference to a successor agency or department. Official comment. No prior provision. Section 105. Electronic records and signatures. This Act modifies, limits, and supersedes the Federal Electronic Signatures in Global and National Commerce Act, but does not modify, limit, or supersede Section 101, c, of that Act, 15 U.S.C. Section 7001, c, or authorize electronic delivery of any of the notices described in Section 103, b, of that Act, 15 U.S.C. Section 7003, b. This Act authorizes the filing of records and signatures, when specified by provisions of this Act or by a rule adopted or order issued under this Act, in a manner consistent with Section 104, a, of that Act, 15 U.S.C. Section 7004, a. Official comment. No prior provision. The purpose of this section is to permit the filing of electronic signatures and electronic records. 37 Article 2 Exemptions from registration of securities. Official comments. Section 201 includes exempt securities and Section 202 includes exempt transactions. Both exempt securities and exempt transactions are exempt from the securities registration, notice filing requirement of Section 302, and the filing of sales literature. Section 504 of this Act. Neither Section 201 nor Section 202 provides an exemption from the Act's anti-fraud provisions in Article 5, nor the broker-dealer, agent, investment advisor, or investment advisor registration requirements in Article 4. A Section 201 exempt security retains its exemption when initially issued and in subsequent trading. A Section 202 transaction exemption must be established for each transaction. Neither the exempt security nor the transaction exemptions are meant to be mutually exclusive. A security or transaction may qualify for two or more exemptions. Article 2 is not available to any security, transaction, or offer that, although in technical compliance with a specific section in Article 2,
is part of an unlawful plan or scheme to evade the registration provisions of Article 3. In such cases registration is required. Cf. Prelim. Note 6 to Regulation D adopted under the Securities Act of 1933. Section 201. Exempt securities. The following securities are exempt from the requirements of Sections 301 through 306 and 504. 1. A security, including a revenue obligation or a separate security as defined in Rule 131, 17 CFR 230.131, adopted under the Securities Act of 1933, issued, insured, or guaranteed by the United States, by a state, by a political subdivision of a state, by a public authority, agency, or instrumentality of one or more states, by a political subdivision of one or more states, or by a person controlled or supervised by and acting as an instrumentality of the United States under 38 authority granted by the Congress, or a certificate of deposit for any of the foregoing. 2. A security issued, insured, or guaranteed by a foreign government with which the United States maintains diplomatic relations, or any of its political subdivisions, if the security is recognized as a valid obligation by the issuer, insurer, or guarantor. 3. A security issued by and representing or that will represent an interest in or a direct obligation of, or be guaranteed by, a. an international banking institution, b. a banking institution organized under the laws of the United States, a member bank of the Federal Reserve System, or a depository institution a substantial portion of the business of which consists or will consist of receiving deposits or share accounts that are insured to the maximum amount authorized by statute by the Federal Deposit Insurance Corporation, the National Credit Union Share Insurance Fund, or a successor authorized by federal law or exercising fiduciary powers that are similar to those permitted for national banks under the authority of the Comptroller of Currency pursuant to Section 1 of Public Law 87-722, 12 U.S.C. Section 92A, or, c. any other depository institution, unless by rule or order the administrator proceeds under Section 204. 4. A security issued by and representing an interest in, or a debt of, or insured or guaranteed by, an insurance company authorized to do business in the state. 5. A security issued or guaranteed by a railroad, other common carrier, public utility or public utility holding company that is, a. regulated in respect to its rates and charges by the United States or a state. 39. b. regulated in respect to the issuance or guarantee of the security by the United States, a state, Canada, or a Canadian province or territory, or, c. a public utility holding company registered under the Public Utility Holding Company Act of 1935 or a subsidiary of such a registered holding company within the meaning of that act. 6. A federal covered security specified in Section 18, b. 1. of the Securities Act of 1933, 15 U.S.C. Section 77 R, b. 1, or by rule adopted under that provision or a security listed or approved for listing on another securities market specified by rule under this Act, a put or a call option contract, a warrant, a subscription right on or with respect to such securities, or an option or similar derivative security on a security or an index of securities or foreign currencies issued by a clearing agency registered under the Securities Exchange Act of 1934 and listed or designated for trading on a national securities exchange, a facility of a national securities exchange, or a facility of a national securities association registered under the Securities Exchange Act of 1934 or an offer or sale of the underlying security in connection with the offer, sale, or exercise of an option or other security that was exempt when the option or other security was written or issued, or an option or a derivative security designated by the Securities and Exchange Commission under Section 9, b. of the Securities Exchange Act of 1934, 15 U.S.C. Section 78 I, b. 7. A security issued by a person organized and operated exclusively for religious, educational, benevolent, fraternal, charitable, social, athletic, or reformatory purposes, or as a chamber of commerce, and not for pecuniary profit, no part of the net earnings of which inures to the benefit of a private stockholder or other person, or a security of a company that is excluded 40 from the definition of an investment company under Section 3, c. 10, b, of the Investment Company Act of 1940, 15 U.S.C. Section 80b3, c. 10, b, except that with respect to the offer or sale of a note, bond, debenture, or other evidence of indebtedness issued by such a person, a rule may be adopted under this Act limiting the availability of this exemption by classifying securities, persons, and transactions, imposing different requirements for different classes, specifying with respect to paragraph b, the scope of the exemption and the grounds for denial or suspension, and requiring an issuer, a, to file a notice specifying the material terms of the proposed offer or sale and copies of any proposed sales and advertising literature to be used, and provide that the exemption becomes effective if the administrator does not disallow the exemption within the period established by the rule. b, to file a request for exemption authorization for which a rule under this Act may specify the scope of the exemption, the requirement of an offering statement, the filing of sales and advertising literature, the filing of consent to service of process complying with Section 611, and grounds for denial or suspension of the exemption, or, c, to register under Section 304, 8, a member's or owner's interest in, or a retention certificate or like security given in lieu of a cash patronage dividend issued by a cooperative organized and operated as a non-profit membership cooperative under the cooperative laws of a state, but not a member's or owner's interest, retention certificate, or like security sold to persons other than bona fide members of the cooperative, and 9. An equipment trust certificate with respect to equipment leased or conditionally sold to 41 a person, if any security issued by the person would be exempt under this section or would be a federal covered security under Section 18, b, 1, of the Securities Act of 1933, 15 U.S.C. Section 77R, b, 1. Official comments. Prior provisions, 1956 Act Section 402, a, RUSA Section 401, b. 1 Section 201, 1 United States Government and Municipal Securities, Prior Provisions, 1956 Act Section 402, a, 1, RUSA Section 401, b, 1. This exemption generally follows the 1956 Act except that it adds securities insured by a specified government to those issued or guaranteed. RUSA, in contrast, also addressed foreign governments, which in this Act are treated separately in Section 201, 2. Rule 131 issued under the Securities Act of 1933 defines separate securities issued under governmental obligations. A significant minority of states have excluded from the Section 201, 1, exemption industrial revenue bonds. Interest on these securities is solely repayable from revenues received from a non-governmental industrial or commercial enterprise. Typically this exclusion will not operate if, a, the payments are made or unconditionally guaranteed by a person whose securities are exempt from registration under Section 18, b, 1, of the Securities Act of 1933, or, b, in accordance with a rule under this Act, the issuer first files a notice in a record specifying the terms of the proposed offer or sale and a copy of the offering statement, and the administrator does not disallow the exemption within the time period established by the rule. 2 Section 201, 2 Foreign Government Securities, Prior Provisions, 1956 Act Section 402, a, 2. RUSA Section 401, b, 2. The 1956 Act, as amended, and RUSA both reached foreign governments as specified in Section 201, 2, and separately treated as security issued, insured, or guaranteed by Canada, a Canadian province or territory, a political subdivision of Canada or a Canadian province or territory, an agency, or corporate or other instrumentality of one or more of the foregoing. The separate treatment of Canadian securities is largely redundant and has been eliminated from this section. 3 Section 201, 3. Depository institution and international banking institution securities, prior provision, RUSA 401, b. 3. Section 402, a. 3, of the 1956 Act exempts specified bank and similar depository institutions, Section 402, a. 4, exempts specified savings and loan and similar thrift institution securities, and Section 402, a. 6, exempts specified credit union securities. RUSA Section 401, b. 3, combines the three types of depository institutions into a common definition, see RUSA Section 101, 13, which are adopted in this Act as Sections 102, 3, and 102, 5, and a common exemption, see RUSA Section 401, b. 3, which is adopted in this subsection. 42 banks specified in Section 3, a. 2, of the Securities Act of 1933 issue federal covered securities under Section 18, b. 4, c, of the Securities Act of 1933. Section 201, 3, c, applies to securities issued by depository institutions without depository insurance. Under Section 204, the administrator will have the ability to revoke or limit this exemption. For Section 201, for insurance company securities, prior provisions, 1956 Act Section 402, a. 5, RUSA Section 401, b. 4. The issuance, insurance, or guarantee of securities by an insurance company is extensively regulated by state insurance commissions or other state agencies. Under this Act, insurance, endowment policies, or annuity contracts under which an insurance company promises to pay fixed sums are excluded from the definition of a security in Section 102, 28, b. Unless brackets are removed from the words or variable in Section 102, 28, b, a variable annuity or other variable insurance product would be considered a security under this Act and under federal securities law. See SECV Variable Annuity Life INS Co. of AM, 359 U.S. 65, 1959, SECV United Benefit Life INS Co., 387 U.S. 202, 1967. A variable annuity or other variable insurance product issued by an investment company registered with the Securities and Exchange Commission under the Investment Company Act of 1940 would be a federal covered security, see Section 102, 7. See Lander v. Hartford Life and Annuity INS Co., 251 F.3d 101, 2d Sir 2001. A variable annuity or other variable insurance product not issued by a registered investment company would be exempted by Section 201, 4, but would be subject to the anti-fraud provisions in Article 5. 5. Section 201, 5. Common carrier and public utility securities, prior provisions, 1956 Act Section 401, a. 7, RUSA Section 401, b. 5. Both the 1956 Act and RUSA include references, omitted here, to the Interstate Commerce Commission, whose enabling legislation subsequently was repealed. Public utility holding companies covered by this exemption are subject both to the Public Utility Holding Company Act and to state or Canadian utility regulation. 6. Section 201, 6. Certain options and rights, no prior provision. The 1956 Act Section 402, a. 8, provided an exemption for securities listed on the New York, American, Midwest, now Chicago, or other designated stock exchanges, senior or substantially equal securities of the same issuer listed on the exchange and any security covered by listed or approved subscription rights or warrants, or any warrant or right to purchase or subscribe to any security exempted by Section 402, a. 8. RUSA essentially retained this exemption in Section 401, b. 7, and added securities designated for inclusion in the national market system by the National Association of Securities 43 dealers in Section 401, b. 8, and specified options issued by a clearing agency registered under the Securities Exchange Act of 1934 in Section 401, b. 9.
In 1996 Congress enacted the National Securities Markets Improvement Act and provided in Section 18, b. 1, that securities listed on the New York, American, or Nasdaq Stock Exchange, or designated by rule of the Securities and Exchange Commission, as well as any security of the same issuer that is equal in seniority or senior to any of these securities will be a federal covered security. Under Rule 146 the SEC has designated as federal covered securities under Section 18, b. 1, Tier I of the Pacific Exchange, Tier I of the Philadelphia Stock Exchange, and the Chicago Board Options Exchange on condition that the relevant listing standards continue to be substantially similar to those of the New York, American, or Nasdaq stock markets. See Reporter's Note to Section 102, 7. A federal covered security subject to Section 18, b. 1, of the Securities Act of 1933 will not be subject to the securities registration requirements of Sections 301 and 303 through 306. The exemption in Section 201, 6, addresses specified options, warrants, and rights that are not federal covered securities under Section 18, b. 1, of the Securities Act of 1933, but generally would have been exempted under RUSA. The 1956 Act, which was narrower, was drafted before the computerized Nasdaq stock market began trading the national market list and the development of standardized options markets. The final clause of Section 201, 6, makes clear that any offer or sale of the underlying security that occurs as a result of the offer or sale of an option or other derivative security exempted under this provision or as the result of the exercise of the option or other derivative security, is covered by the exemption if the option met the terms of the exemption at the time such derivative security was written, that is, sold, or issued. The sale of the underlying security when an option is exercised would be exempt even if the underlying security is not at that time subject to any exemption under the Act. This is consistent with existing precedent under federal law suggesting that the legality of the sale of an underlying security when an option is exercised should be determined by the status of the security at the time the option was written rather than at the time of exercise. See, e.g., H. Cook & Co., Inc. v. Steinman, Hokeston, and Trotta, Inc., 414 F.2d 93, 2d Sir 1969. Any transaction in an underlying security that results from the offer, sale, or exercise of any derivative security issued by a registered clearing agency and traded on a national securities exchange or association is exempt if the derivative security when written was exempt under Section 201, 6. The Securities and Exchange Commission has adopted Rule 9b1 under Section 9b. 7 Section 201, 7 Nonprofit Organization Securities, Prior Provision, Section 3, A, 4, of the Securities Act of 1933. Section 402, A, 9, of the 1956 Act and Section 401, B, 10, of RUSA exempt specified nonprofit securities. Both are modeled on Section 3, A, 4, of the Securities Act, which was subsequently amended. 44 securities issued under Section 3, A, 4, of the Securities Act of 1933 are not treated as federal covered securities in Section 18, B, 4, C, although a separate Section 3, A, 13, exemption which addresses certain church plan securities are federal covered securities under Section 18, B, 4, C. RUSA included an optional notice and review requirement for nonprofit securities in Section 401, B, 10, if at least 10 days before a sale of the security the person has filed with the administrator a notice setting forth the material terms of the proposed sale and copies of any sales and advertising literature to be used and the administrator by order does not disallow the exemption within the next 5 full business days. The nonprofit exemption is of particular concern to state securities administrators. See, e.g., state regulators announce dramatic rise in religious scams, tens of thousands lured, 33 seconds reg. NL Republic, BNA, 1189, 2001. Under Section 6 of the Philanthropy Protection Act,
Congress preempted application of the registration provisions of state securities laws to issuance of securities covered by Section 3, c. 10, of the Investment Company Act of 1940 unless states acted within 3 years of enactment, December 1998, to pass special state legislation canceling federal preemption. 10 states enacted such legislation. Those states may preserve this treatment of Section 3, c. 10, securities by deleting from Section 201(7), the phrase "or a security of a company" that is excluded from the definition of an investment company under Section 3, c. 10, b, of the Investment Company Act of 1940. Section 201(7) provides statutory authority for the states to adopt rules with respect to notes, bonds, debentures and other evidences of indebtedness issued by nonprofit organizations. Each state may adopt different rules tailored for various types of nonprofit debt offerings, e.g., local church bond offerings, national church bond offerings, church extension funds, charitable gift annuities. For states that do not wish to provide an automatic exemption from registration for a particular type of nonprofit debt instrument or offering, Section 201(7) creates 3 categories of regulatory review that may be required by rule: a. Exemption by notice filing, b. Exemption by state authorization, and c. Registration by qualification. These categories are consistent with the manner in which many states currently review different types of nonprofit debt securities. See Horner and Makins, Securities Regulation of Religious and Other Nonprofit Organizations, 27 Stetson L. Revelation 473, 1997. 8 Section 201, 8 Cooperatives, Prior Provision, RUSA Section 401, b. 13. Section 201, 8, is derived from RUSA Section 401, b. 13, which was included in that act after a number of states had adopted exemptions for securities issued by cooperatives. Section 201, 8, is not intended to be available if securities are offered or sold to the public generally. The 1956 Act Section 402, a. 12, had instead provided, insert any desired exemption for cooperatives. The reporter for the 1956 Act had found such sharp variation among the 18 states that then had adopted a cooperative exemption that no common pattern can be found. 45 Lewis Loss, Commentary on the Uniform Securities Act 118, 1976. 9 Section 201, 9 Equipment Trust Certificates, Prior Provision, RUSA Section 401, b. 6. The Securities Act of 1933 Section 3, a. 6, includes a narrower exemption for railroad equipment trusts. Section 201, 9, follows RUSA. The official comment to RUSA Section 401, b. 6, explained, the new paragraph, b. 6, reflects the extensive development of equipment lease financing through leveraged leases, conditional sales, and other devices. The underlying premise is that if the securities of the person using such a financing device would be exempt under some other paragraph of Section 401, the equipment trust certificate or other security issued to acquire the property in question also is exempt. Section 202. Exempt transactions. The following transactions are exempt from the requirements of Sections 301 through 306 and 504. 1. An isolated noni-suor transaction, whether effected by or through a broker-dealer or not. 2. A noni-suor transaction by or through a broker-dealer registered, or exempt from registration under this Act, and a resale transaction by a sponsor of a unit investment trust registered under the Investment Company Act of 1940, in a security of a class that has been outstanding in the hands of the public for at least 90 days, if, at the date of the transaction, a. the issuer of the security is engaged in business, the issuer is not in the organizational stage or in bankruptcy or receivership, and the issuer is not a blank check, blind pool, or shell company that has no specific business plan or purpose or has indicated that its primary business plan is to engage in a merger or combination of the business with,
or an acquisition of, an unidentified person. B. The security is sold at a price reasonably related to its current market price. 46. C. The security does not constitute the whole or part of an unsold allotment to, or a subscription or participation by, the broker-dealer as an underwriter of the security or a redistribution, and D. A nationally recognized securities manual or its electronic equivalent designated by rule adopted or order issued under this Act or a record filed with the Securities and Exchange Commission that is publicly available contains, a description of the business and operations of the issuer, 2. The names of the issuer's executive officers and the names of the issuer's directors, if any, 3. An audited balance sheet of the issuer as of a date within 18 months before the date of the transaction or, in the case of a reorganization or merger when the parties to the reorganization or merger each had an audited balance sheet, a pro forma balance sheet for the combined organization, and, 4. An audited income statement for each of the issuer's 2 immediately previous fiscal years or for the period of existence of the issuer, whichever is shorter, or, in the case of a reorganization or merger when each party to the reorganization or merger had audited income statements, a pro forma income statement, or, the issuer of the security has a class of equity securities listed on a national securities exchange registered under the Securities Exchange Act of 1934 or designated for trading on the National Association of Securities Dealers Automated Quotation System, unless the issuer of the security is a unit investment trust registered under the Investment Company Act of 1940, or the issuer of the security, including its predecessors, has been engaged in continuous 47 business for at least 3 years, or the issuer of the security has total assets of at least $2 million based on an audited balance sheet as of a date within 18 months before the date of the transaction or, in the case of a reorganization or merger when the parties to the reorganization or merger each had the audited balance sheet, a pro forma balance sheet for the combined organization. 3. A non-issue or transaction by or through a broker-dealer registered or exempt from registration under this Act in a security of a foreign issuer that is a margin security defined in regulations or rules adopted by the Board of Governors of the Federal Reserve System. 4. A non-issue or transaction by or through a broker-dealer registered or exempt from registration under this Act in an outstanding security if the guarantor of the security files reports with the Securities and Exchange Commission under the reporting requirements of Section 13 or 15, d, of the Securities Exchange Act of 1934, 15 U.S.C. 78M or 780, d. 5. A non-issue or transaction by or through a broker-dealer registered or exempt from registration under this Act in a security that, a, is rated at the time of the transaction by a nationally recognized statistical rating organization in one of its 4 highest rating categories, or, b, has a fixed maturity or a fixed interest or dividend, if, a default has not occurred during the current fiscal year or within the 3 previous fiscal years or during the existence of the issuer and any predecessor if less than 3 fiscal years, in the payment of principal, interest, or dividends on the security, and, 2, the issuer is engaged in business, is not in the organizational stage or in bankruptcy or receivership, and is not and has not been within the previous 12 months a blank check, blind pool, or shell company that has no specific business plan or purpose or has indicated 48 that its primary business plan is to engage in a merger or combination of the business with, or an acquisition of, an unidentified person. 6. A non-issue or transaction by or through a broker-dealer registered or exempt from registration under this Act affecting an unsolicited order or offer to purchase. 7. A non-issue or transaction executed by a bona fide pledgee without the purpose of evading this Act. 8. A non-issue or transaction by a federal covered investment advisor with investments under management in excess of $100 million acting in the exercise of discretionary authority in a signed record for the account of others. 9. A transaction in a security, whether or not the security or transaction is otherwise exempt, in exchange for one or more bona fide outstanding securities, claims, or property interests, or partly in such exchange and partly for cash,
if the terms and conditions of the issuance and exchange or the delivery and exchange and the fairness of the terms and conditions have been approved by the administrator after a hearing. 10. A transaction between the issuer or other person on whose behalf the offering is made and an underwriter, or among underwriters. 11. A transaction in a note, bond, debenture, or other evidence of indebtedness secured by a mortgage or other security. Agreement if a. The note, bond, debenture, or other evidence of indebtedness is offered and sold with the mortgage or other security agreement as a unit. b. A general solicitation or general advertisement of the transaction is not made, and c. A commission or other remuneration is not paid or given, directly or indirectly, to 49 a person not registered under this Act as a broker-dealer or as an agent. 12. A transaction by an executor, administrator of an estate, sheriff, marshal, receiver, trustee in bankruptcy, guardian, or conservator. 13. A sale or offer to sell to a. An institutional investor, b. A federal covered investment advisor, or c. Any other person exempted by rule adopted or order issued under this Act. 14. A sale or an offer to sell securities of an issuer, if part of a single issue in which a. Not more than 25 purchasers are present in the state during any 12 consecutive months, other than those designated in paragraph 13. b. A general solicitation or general advertising is not made in connection with the offer to sell or sale of the securities. c. A commission or other remuneration is not paid or given, directly or indirectly, to a person other than a broker-dealer registered under this Act or an agent registered under this Act for soliciting a prospective purchaser in the state, and d. The issuer reasonably believes that all the purchasers in the state, other than those designated in paragraph 13, are purchasing for investment. 15. A transaction under an offer to existing security holders of the issuer, including persons that at the date of the transaction are holders of convertible securities, options, or warrants, if a commission or other remuneration, other than a standby commission, is not paid or given, directly or indirectly, for soliciting a security holder in the state. 16. An offer to sell, but not a sale, of a security not exempt from registration under the 50 Securities Act of 1933 if a registration or offering statement or similar record as required under the Securities Act of 1933 has been filed, but is not effective, or the offer is made in compliance with Rule 165 adopted under the Securities Act of 1933, 17 CFR 230.165, and b. A stop order of which the offerer is aware has not been issued against the offerer by the administrator or the Securities and Exchange Commission, and an audit, inspection, or proceeding that is public and that may culminate in a stop order is not known by the offerer to be pending. 17. An offer to sell, but not a sale, of a security exempt from registration under the Securities Act of 1933 if a. A registration statement has been filed under this Act, but is not effective, b. A solicitation of interest is provided in a record to offerees in compliance with a rule adopted by the administrator under this Act, and c. A stop order of which the offerer is aware has not been issued by the administrator under this Act, and an audit, inspection, or proceeding that may culminate in a stop order is not known by the offerer to be pending. 18. A transaction involving the distribution of the securities of an issuer to the security holders of another person in connection with a merger, consolidation, exchange of securities, sale of assets, or other reorganization to which the issuer, or its parent or subsidiary and the other person, or its parent or subsidiary, are parties. 19. A rescission offer, sale, or purchase under Section 510, 20. An offer or sale of a security to a person not a resident of the state and not present in 51 the state if the offer or sale does not constitute a violation of the laws of the state or foreign jurisdiction in which the offeree or purchaser is present and is not part of an unlawful plan or scheme to evade this Act. 21. Employee stock purchase, savings, option, profit sharing, pension, or similar employees benefit plan, including any securities. plan interests, and guarantees issued under a compensatory benefit plan or compensation contract, contained in a record, established by the issuer, its parents, its majority-owned subsidiaries, or the majority-owned subsidiaries of the issuer's parent for the participation of their employees, including offers or sales of such securities to a. directors, general partners, trustees, if the issuer is a business trust, officers, consultants, and advisors, b. family members who acquire such securities from those persons through gifts or domestic relations orders, c. former employees, directors, general partners, trustees, officers, consultants, and advisors if those individuals were employed by or providing services to the issuer when the securities were offered, and d. insurance agents who are exclusive insurance agents of the issuer, or the issuer's subsidiaries or parents, or who derive more than 50% of their annual income from those organizations. 22. A transaction involving a stock dividend or equivalent equity distribution, whether the corporation or other business organization distributing the dividend or equivalent equity distribution is the 52 issuer or not, if nothing of value is given by stockholders or other equity holders for the dividend or equivalent equity distribution other than the surrender of a right to a cash or property dividend, if each stockholder or other equity holder may elect to take the dividend or equivalent equity distribution in cash, property, or stock. B. An act incident to a judicially approved reorganization in which a security is issued in exchange for one or more outstanding securities, claims, or property interests, or partly in such exchange and partly for cash, or c. the solicitation of tenders of securities by an offerer in a tender offer in compliance with Rule 162 adopted under the Securities Act of 1933, 17 CFR 230.162. Or, 23, a noni-suor transaction in an outstanding security by or through a broker-dealer. Registered or exempt from registration under this Act, if the issuer is a reporting issuer in a foreign jurisdiction designated by this paragraph or by rule adopted or order issued under this Act, has been subject to continuous reporting requirements in the foreign jurisdiction for not less than 180 days before the transaction, and the security is listed on the foreign jurisdiction securities exchange that has been designated by this paragraph or by rule adopted or order issued under this Act, or is a security of the same issuer that is of senior or substantially equal rank to the listed security, or is a warrant or right to purchase or subscribe to any of the foregoing. For purposes of this paragraph, Canada, together with its provinces and territories, is a designated foreign jurisdiction, and the Toronto Stock Exchange, Inc., is a designated securities exchange. After an administrative hearing in compliance with the State Administrative Procedure Act, the administrator, by rule adopted or order issued under this Act, may revoke the designation of a securities exchange under this paragraph, if the administrator finds that revocation is necessary. 53 or appropriate in the public interest and for the protection of investors. Official comments. Prior provisions, 1956 Act Section 402, b. RUSA Section 402. 1 Sections 202, 1, through 8, are available only for noni-suor transactions. An issuer selling securities in an initial public offering or other offering may not rely on Sections 202, 1, through 8. A noni-suor, however, can rely on any issuer transaction exemption such as Section 202, 13, when the exemption would be applicable to a noni-suor. The term noni-suor transaction or noni-suor distribution is defined in Section 102, 18, the term issuer is defined in Section 102, 17. 2 Section 202, 1 Isolated noni-suor transactions, prior provisions, 1956 Act Section 402, b. 1, RUSA Section 402, 1. The term isolated transaction is not defined in this Act, but left to the states to develop. Historically, under state law there has been somewhat varied case law development of the term isolated transactions. See, e.g., Blinder, Robinson & Co., Inc. v. Goch,
403 N.W.2D 772, Iowa 1987, isolated noni-sewer transaction exemption is not unconstitutionally vague, Allen v. Schaaf, 449 P.2D 1010, Kansas 1969, regulation defined isolated transactions to not exceed 4 persons solicited in a 12-month period, Nelson v. State, 355 P.2D 413, 420, Oklahoma CTCRIM App 1960, An isolated sale means one standing alone, disconnected from any other, see generally 1 Lewis Loss and Joel Seligman. Securities Regulation 125 to 130, 3D ed. Rev 1998. In general, this subsection is intended to cover the occasional sale by a person. It would not exempt multiple or successive transactions by a person or group, whether those sales are sufficient to constitute a distribution, as that term is used for purposes of the federal securities laws, see 2 Lewis Loss and Joel Seligman, Securities Regulation 1138.50 to 1138.52, 3D ed. Rev 1999, or merely too frequent to be considered isolated under the relevant state law. Limited issuer offering transactions are separately addressed in Section 202, 14. 3. Section 202, 2 noni-sewer transactions in specified outstanding securities, prior provisions, 1956 Act Section 402, b. 2, RUSA Sections 402, 3, and 4. This section represents a modernization of the Securities Manual exemption, which was included in both the 1956 Act and RUSA. NASAA recommended an amendment to the 1956 Act Section 402, b, after discussion with the Securities Industry Association and others in the securities industry. This section generally follows the NASAA amendment. Rule 419 issued under the Securities Act of 1933 defines a blank check company to be a company that is a development stage company that has no specific business plan or purpose, or has indicated that its business plan is to engage in a merger or acquisition with an unidentified company or companies, or other entity or person. A blind pool is similar and would involve 54 an investment in a blank check or other entity with no identified business plan or purpose. A shell company is also similar and would involve an entity which, to date, has no significant business assets, plan, or purpose. For Section 202, 3 noni-sewer transactions in specified foreign transactions, no prior provision. The NASAA recommendation that was the basis of Section 202, 2, also included specified foreign noni-sewer transactions subject to a manual exemption when there was disclosure of the issuer's officers and directors in the issuer's country of domicile. This subsection uses margin securities as an alternative approach to identify sufficiently seasoned foreign securities. Margin securities are required to be in compliance with Regulation T, which was adopted by the Board of Governors of the Federal Reserve System. 5. Section 202, 4 noni-sewer transactions in securities subject to Securities Exchange Act reporting, prior provision, RUSA Section 402, 2. RUSA added this exemption to authorize noni-sewer secondary trading in the securities of issuers that were subject to the periodic reporting requirements of the Securities Exchange Act of 1934. To bar immediate secondary trading in non-registered initial public offerings, there was a further requirement that these securities be subject to the reporting requirements of Sections 13 or 15, d, of the Securities Exchange Act of 1934 for not less than 90 days. Section 202, 4, only covers the guarantor because if the issuer of the security is a reporting company under Sections 13 or 15, d, of the Securities Exchange Act of 1934, the transaction is preempted by Section 18, b, 4, a, of the Securities Act of 1933. Section 18, b, 4, a, of the National Securities Markets Improvement Act of 1996 defines noni-sewer transactions under Section 4, 1, of the Securities Act of 1933, transactions by persons other than an issuer, underwriter, or dealer, as federal covered securities, See Section 102, 7, if the issuer files reports with the Securities and Exchange Commission under Sections 13 or 15, d, of the Securities Exchange Act of 1934. Under Section 18, a, of the Securities Act of 1933 no state statute, rule, order, or other administrative action with respect to registration of securities or reporting requirements may apply to a federal covered security. To harmonize Section 202, 4, with Sections 18, a, and 18, b, 4, a, of the Securities Act of 1933, the 90-day reporting period in RUSA's Section 402, 2, is not adopted in this Act. 6. Section 202, 5 non-issuer transactions in specified fixed income securities, prior provisions, 1956 Act Section 402, b, 2, b, RUSA's Section 402, 4. The concept of a fixed income security rated by a nationally recognized statistical rating organization in one of its 4 highest rating categories described in Section 202, 5a, is well established in federal securities law in Form S-3 adopted under the Securities Act of 1933 and the Net Capital Rule 15C31, c. 2, 6, f, adopted under the Securities Exchange Act of 1934. C2 Lewis Loss and Joel Seligman, Securities Regulation 649-653, 3D ed. Rev. 1999. Nationally recognized statistical rating organizations have been identified by the Securities and Exchange Commission and include such organizations as Moody's and Standard & Poor's. Rating categories typically begin with AAA and under this Act would include BBB as the 4th highest rating category. 55 Section 202, 5b, follows the 1956 Act and RUSA, but also addresses blank check and similar offerings, which became major concerns at the state and federal levels during the past 2 decades. Cf. Securities Act of 1933 Rule 419. See Official Comment, 3. This subsection includes both debt securities with fixed maturity or a fixed interest rate and preferred stock with fixed dividend provisions. 7. Section 202, 6 Unsolicited brokerage transactions, prior provisions, 1956 Act Section 402, b, 3, RUSA's Section 402, 5. Section 18, b, 4, b, of the Securities Act of 1933 defines as federal covered securities those subject to Section 4, 4, of the Securities Act of 1933, brokerage transactions executed upon customers' orders on any exchange or in the over-the-counter market but not the solicitation of such orders. Section 202, 6, is intended to provide exemption for known agency transactions by dealers not within the scope of Section 4, 4. The 1956 Act Section 402, b, 3, had provided that the administrator may by rule require that the customer acknowledge upon a specified form that the same was unsolicited, and that a signed copy of each such form be preserved by the broker-dealer for a specified period. This type of requirement is preempted by Section 18a of the Securities Act of 1933 for federal covered securities and is viewed as unnecessary for the limited class of dealer-known agency transactions that will be exempted by Section 202, 6. 8. Section 202, 7 Non-issuer transactions by pledges, prior provisions, 1956 Act Section 402, b, 7, RUSA's Section 402, 9. This subsection is identical to the 1956 Act and substantively identical to RUSA. 9. Section 202, 8 Non-issuer transactions with federal covered investment advisors, no prior provision. This exemption was added because of a recognition that federal covered investment advisors are sophisticated financial professionals capable of determining the merits of a security and do not require the protections provided by requiring registration in a particular state. 10. Section 202, 9 Specified exchange transactions, no prior provision. Section 202, 9, provides a state counterpart to the exemption in Section 3a, 10, of the Securities Act of 1933. 11. Section 202, 10 Underwriter transactions,
Prior provisions, 1956 Act Section 402, b. 4, RUSA Section 402, 6. This subsection is substantively identical to the 1956 Act and RUSA. 12 Section 202, 11 Unit Secured Transactions, Prior Provisions, 1956 Act Section 402, b. 5, RUSA Section 402, 7. In recent years the application of this exemption has been one of concern to state securities administrators. The conditions that conclude this exemption are new and are intended to address these concerns. 5613. Section 202, 12 Bankruptcy, Guardian, or Conservator Transactions, Prior Provisions, 1956 Act Section 402, b. 6, RUSA Section 402, 8. This subsection is identical to that in the 1956 Act and RUSA. 14 Section 202, 13 Transactions with Specified Investors, Prior Provision, 1956 Act Section 402, b. 8. The 1956 Act contains similar but less inclusive language in Section 402, b. 8. If the Securities and Exchange Commission adopts a rule defining qualified purchaser as used in Section 18, b. 3, of the Securities Act to specify certain purchasers of federal covered securities, part or all of this exemption will be redundant. As of September 2002, the Commission has proposed, but not adopted, Rule 146, c. Section 202, 13, b, is limited to transactions for the account of a federal covered investment advisor and is not intended to reach transactions on behalf of others by such advisor. 15 Section 202, 14 Limited Offering Transactions, Prior Provisions, 1956 Act Section 402, b. 9, RUSA Section 402, 11. The reference in the prefatory language to a single issue signifies that two or more issues can be integrated and potentially destroy the exemption. There are two general tests for integration under the federal securities laws. The states similarly have followed generally these types of integration principles with respect to securities transaction exemptions. First, there is a 6-month buffer before and after an offer, offer to sell, or sale of a transaction exempt under Section 202, 14, during which no other issue can be distributed if integration automatically is to be avoided. See Rule 147, b. 2, and Rule 502, a, of the Securities Act of 1933. Second, if two issues occur within 6 months, integration may occur depending upon the following factors: I. Are the offerings part of a single plan of financing? 2. Do the offerings involve issuance of the same class of securities? 3. Are the offerings made at or about the same time? 4. Is the same type of consideration to be received? And b. Are the offerings made for the same general purpose? See generally 3 Lewis Loss and Joel Seligman, Securities Regulation 1231-1248, 3D ed. Rev. 1999. Section 402, b. 9, of the 1956 Act and Section 402, 11, of the 1985 Act provide alternative limited offering transaction exemptions. The 1956 Act was limited to offers to no more than 10 persons, other than institutional investors specified in Section 402, b. 8. All purchasers in the state had to purchase for investment, and no remuneration was given for soliciting prospective purchasers in the state. RUSA, in contrast, was limited to no more than 25 purchasers, other than financial or institutional investors, no general solicitation or advertising, and no remuneration was paid to a person other than a broker-dealer for soliciting a prospective purchaser. This section would apply to pre-organization limited offerings as well as operating company 57 limited offerings. The Securities Act of 1933 Sections 3, b, and 4, 2, also apply to both. In contrast, the 1956 Act Section 402, b, 10, and RUSA Section 402, 12, used similar concepts in separate sections to apply to pre-organization limited offerings. Section 18, b, 4, d, of the Securities Act of 1933 defines as federal covered securities those issued under Securities and Exchange Commission rules under Section 4, 2, of the Securities Act. This would include Rule 506, which uses the accredited investor definition in Rule 501a. When a transaction involves Rule 506, Section 18, b, 4, d, further provides that this paragraph does not prohibit a state from imposing notice filing requirements that are substantially similar to those required by rule or regulation under Section 4, 2, that are in effect on September 1, 1996. These notice requirements are found in Section 302, c, of this Act. A majority of states have adopted a uniform limited offering exemption, coordinate to varying degrees with Regulation D. The authority to adopt this and other exemptive rules is provided in Section 203. 16 Section 202, 15 Transactions with existing security holders, Prior Provisions, 1956 Act